A brief argument if council have anything further to add to what's been presented already in regards to the items of evidence that the prosecution proposes to introduce regarding spending activity of the defendant Erik Menendez. The defense offered this evidence, so let me hear the position of the defense.
Your Honor, Exhibit 137, which is the paperwork regarding the Marina City Club condominium, is entirely in the name of Lyle Menendez, or Joseph Lyle Menendez. The proposed purchase is in his name. Every signature on the documents appears to be Lyle's signature and not Erik's. The only indication of Erik's involvement is in the form of a copy of a check that Erik wrote as a deposit for this unconsummated purchase. The testimony of Mr. Goldberg clearly establishes that was a loan to his brother who expected to be paid back, and that Erik did not take part in any way in the purchase of this condominium. That this was a purchase by Lyle and not Erik. So given that paperwork, the documents which memorialize the transaction themselves demonstrate that this is not evidence that should be admissible against Erik. The fact that he loaned him money so that Lyle could buy a condominium in the Marina certainly is not anything that we should that should be allowed before Erik's jury. With respect to the Jeep, very briefly, I will submit it. And with respect to the Mark Heffernan contract, I think that the evidence before the court indicates that this was a contract that was entered into with an expectation that a portion, a significant portion, if not all, of the money to be spent for Mr. Heffernan's services would be reimbursed by money or an agreement with Live Entertainment that contemplated them sponsoring Erik on the Pro Tour for 1 year. So again, given the record that is before the court, I don't think that any of the proposed lavish spending evidence on Erik's part is in fact lavish spending. And I think to introduce this evidence before the jury in an attempt to prove what it can, which is that Erik was spending wildly, is not, the evidence is not sufficiently probative to justify the amount of litigation that would be required to have the jury truly understand what was going on and what these transactions were really about.
Well, in response, just briefly as to the tennis pro, isn't the argument basically that one way or the other, the defendant Erik Menendez proposed to profit from the death of his father by having this coach deal with his professional aspirations, whether it's by payment of his own, out of his own pocket from the proceeds of the insurance, or by being reimbursed by the father's former employer who took sympathy on the orphaned son of their key employee.
I think, Your Honor, the important part is how could Erik have anticipated prior to the time his parents were killed that the company would agree to reimburse Mr. Heffernan's costs. It's hardly something that Erik would reasonably expect.
Well, the issue is really, is this circumstantial evidence reflective of the defendant's state of mind at the time the killings occurred, or prior to the time the killings occurred, to establish that this was a motive for the killings? And the aspirations apparently were there, the intent to be using a tennis professional in a fashion that appears to be different than what it was before. There was no evidence that I've heard that the family was paying $60,000 a year for the services of a tennis professional for Erik Menendez prior to the killings. That either he was going to pay for it, or ultimately later on he entered into some agreement that someone else was going to pay for it. But the issue is, whether or not this is circumstantial evidence to show his state of mind at the time the killings occurred. We haven't heard much about when these negotiations took place with Mr. Heffernan as to how soon after the killings they occurred. And I don't know if that is within the knowledge of Mr. Goldberg or within the knowledge only of Erik Menendez and Mr. Heffernan. Do you have any information about that, Mr. Kuriyama?
Not specifically when the negotiations began, and I didn't intend to get into all that because there's so many objections to his testimony, but over the lunch hour I can ask him.
No, I mean, do you have any information from Mr. Heffernan? He must know when he started negotiating for a contract to do this.
He believed that they had gotten into the agreement about October, according to the first, one of the reports. The actual contract, the term appears to be January of 1992.
Okay, I would like to hear when it was that the negotiations took place, and that's closer to, apparently closer to when the crimes occurred, and I'd like to know what that was rather than ultimately what the contract was.
Yes, that is the information that is.
Well, you find out from Mr. Heffernan precisely what the information is rather than what's in some police report. We could talk about that at 1:30.
We'd like to have Mr. Goldberg and look on record on his understanding on the negotiation. Because he was doing negotiations.
Well, you can confer with him and both Mr. Kuriyama and you and inform the court if there is such an issue. I doubt very much if Mr. Goldberg was there when Mr. Heffernan and Erik Menendez first broached the subject, that there must have been some prior negotiations and discussions before Mr. Goldberg came on the scene. So I don't know if he is definitive on that subject.
I think we have another witness on that who was here.
Well, I'm not going to go into a trial of this matter. At this point, this is just a preliminary determination as to whether or not there is sufficient justification for this evidence to be introduced and for the court to weigh it under Section 352 of the Evidence Code. And if there is other evidence on that issue, you could briefly inform the court of it to assist the court in making a determination as to what sort of evidence might have to be introduced if the issue was actually before the jury, to assist the court in making its weighing process an informed one under Section 352 of the Evidence Code. Regarding the Jeep, the court finds that that was a purchase made in close proximity to the time the incident occurred, the killings occurred, and as far as the weight of that evidence, that's for the jury to decide. I find that it is circumstantial evidence reflective of the defendant's state of mind at the time of the crime, and it's up to the jury to evaluate it and make their own independent decision on that subject. Regarding the purchase of the condominium, what is your argument, Mr. Kuriyama, as to why this is spending evidence in relationship to the defendant, Erik Menendez, if it was a loan that is not one that the defendant, Erik Menendez, was ultimately going to be involved in the purchase, and it was just a loan to someone else?
Your Honor, first of all, I don't accept that statement or that as fact that it was a loan. Valerie Hart was the person that made the sale. She spoke to the defendants. They came in together and spoke of buying this penthouse suite. And in fact, Erik Menendez is the one that wrote the deposit. It was, in her opinion, they were buying this together. It was a 3,000 square foot penthouse suite with something like 3 bedrooms.
All right, well, not the size of it, just you have a witness who will testify that Erik Menendez gave her the impression that he was a purchaser.
Yes.
All right, has the defense interviewed that witness?
Your Honor, we have received a discovery about Valerie Hart, and quite frankly, the police report regarding her statement lumps the two of them together, so that I would request a hearing outside the presence of the jury as to the foundation for the conclusion expressed in the police report.
Well, have you interviewed her, Mr.
Yes, I
Kuriyama?
have, and pursuant and consistent with the police report, which states they were interested in buying a $990,000, the most expensive penthouse. They were interested. In fact, I asked her about the paperwork, and she said, well, they were going to buy it together. In fact, as I pointed out, Erik Menendez is the one that wrote the deposit check, so it's her.
Okay, we all know that he wrote the check. The issue is whether or not he wrote it because he was buying it or if someone else was buying it and he just made a loan. So I'll let the council speak with Ms. Hart during the lunch hour, and if there's a need for a hearing, we'll hold a brief hearing. But I believe this can be handled just by speaking with her, and if there is a dispute, we'll resolve it at 1:30. All right, we'll be in recess then until 1:30 on these subjects.
Your Honor, may I go in the back hall to retrieve the machine?
In the trial, the defendant, Erik Menendez, is in court with his lawyers. People are represented. And there were a couple of matters that counsel wanted to deal with during the lunch hour. What has been the result of those discussions?
We do have a stipulation on the burglary charge.
And what about the other two matters dealing with spending evidence? Something to do with when negotiations commenced regarding tennis instruction or coaching, and also in relationship to the purchase of the condominium.
Your Honor, Mr. Goldberg would testify if called that he began work on the contract approximately 1 month before it was signed.
And apparently it was for the term as of January through August of 1990. I spoke to Mr. Heffernan, and he believed that he and Erik had spoken about the contract, and it was in October of 1989.
We also could put on testimony from Marta.
And during the course of the discussing the contract, he worked without the contract, he was getting the money, I guess, based on the contract amount. He didn't actually have the written contract related.
As to when did he start working?
His understanding, or his recollection, it was October 1989.
On a full-time basis?
Yes.
It's not.
And
Your Honor.
do you wish to respond to that?
Yeah, well, Marta Cano was prepared to testify that she started talking to Mr. Heffernan about a future contract in late October and November. He was not paid under the contract until there was a contract. He was being paid under the previous contract that he had with the parents, which ran until November. He had a November contract with the parents.
All right, I'd have to hear some testimony perhaps from Mr. Heffernan on that. And regarding the Marina Del Rey or Marina City Club, the purchase and council, we're going to meet with the representative of that business.
Yes, Your Honor. Apparently, Ms. Hart will testify that they came there together and it was her impression that they were buying it together. However, our position is still that Ms. Hart's misimpressions about the nature of the transaction should not be allowed to counter the plain language of the contracts regarding the transaction.
Also, Ms. Lansing has interviewed that with me. She indicated that Lyle Menendez did all of the talking, that Erik was silent through most of it, that Lyle was doing the negotiating, that he signed all the documents. They looked at it together, but she doesn't seem to have any information as to where the money was coming from, but who was gonna live there. She just formed an impression because they worked together.
Your Honor,
All right, why don't you turn on your mic so that you can be heard? Yes.
Evidently, I was told by a reporter that when we whisper to each other, the mic picks it up.
Right.
Well, then turn it off when you're whispering,
Okay.
but otherwise just leave it on. All right, yes.
if I might, Your Honor, the jury heard testimony yesterday, a statement given by Erik Menendez on September 17th of 1989, in which he states that he needs to buy a place with a tennis court, and this fit that bill. It was a upscale condominium complex in Marina Del Rey, and he had expressed a month before that he intended to buy a place such as that.
He didn't buy anything. He wound up leasing.
Okay, counsel, let's behave. One person speak, and then the other can request permission of the court to speak.
It appears that he mentioned Marina Del Rey in the September 17th, 1989 statement.
You mentioned Marina City Club or just?
I don't think the Marina City Club in particular, but Marina Del Rey.
All right, I'll have to hear brief testimony from that witness as well, unfortunately. I say unfortunately because we have both juries waiting. All right, let's first have Mr. Heffernan then, if the people are ready with him. Mr. Heffernan? Yeah.
He was in the men's room a moment ago, Your Honor, with Rob.
Let's see if he's voting.
Now, the inquiry at this point is when negotiations began and who was involved in them?
Yes, that's it.
Okay.
And as to whether there was some pre-existing contract that was just fulfilled after the parents died. If he is not readily available, we have a representative from Marine City Club.
Yes, Your Honor.
If she is available, let's have her.
It's Valerie Hart.
Valerie Hart.
All right, this is just brief testimony. It won't be as extensive as you might otherwise expect. So let's try to get to the point, Mr. Creon.
Okay, thank you, Your Honor. Ms. Hart, I'm going to show you what the mark is. Exhibit 137. I asked you how you were employed on October 15th, 1989.
I work for the developer selling condominiums at the Marina City Towers. And it was my day on duty.
Okay. On that day, in the afternoon, did you have a couple of customers come in that you see in the courtroom today?
Yes,
Or at least one of them?
yes.
Could you identify that person?
That's Erik Menendez.
Okay. Was he accompanied by anybody?
He was with Lyle Menendez and Noel, and I don't know his last name. I think it was
Can you
Ficati.
describe Noel?
He was tall and thin, young, same age as I would guess Erik is, about the same age. Lightish brown hair.
Okay, that's good enough.
Now, at some point, did either Lyle Menendez or Erik Menendez ask to see a penthouse suite?
Yes, they did.
Would you describe for the judge?
You want to object to the use of they, non-responsive to questions?
Would you describe for the judge what occurred when they arrived?
They came in together and they wanted to know what was the largest
When you
condominium.
say they, can you be more specific? Who was asking the question?
It was Lyle.
And what did he say specifically? Did he use the word they?
He said we
We?
would like to see.
Okay, now, we would like to see what?
We would like to see the largest condominium that you have,
And what was that?
a 3,000 square foot penthouse.
Was that a penthouse suite?
Penthouse, yes.
And how much was the sale price of that?
$990,000.
Did you then show the Menendez brothers that condominium
Yes, all three of them.
with this Noel as
Yes.
well? Would you describe for the judge what took place during this time that you were showing this condominium?
I showed it to them and they seemed like they liked it and they were taking quite a bit of time looking at it and talking amongst themselves. And I had other clients that I needed to get back to in my office, so I told them that they could stay there as long as they wanted. And I would be down in my office. I would say that was early afternoon. And several times other salespeople came and said they're still up there. They're still in the penthouse. And I had gone up there one other time. They were still there. Finally, about almost close to closing, which was about 6 o'clock, they came down and said that it was Lyle, said that they wanted to buy the penthouse.
Now, when you went up and you saw them there during this period of time, did Erik Menendez make any statements to you about how he liked the penthouse?
No,
And when they came down and Lyle said that they wanted to buy the penthouse, was Erik with him?
yes, he was.
Did they make any statements to you about wanting to change anything in the interior of the penthouse?
Yes.
Object to use of they.
Be more specific.
Did Were you given any indication that the brothers wanted some changes
Counsel,
done?
let's be more specific as to who did what.
Okay. Did anybody, and I'm not sure, okay, let me ask you this. Did Erik Menendez indicate to you at any time anything that he wanted done that would have changed the interior of the condominium or the penthouse?
I don't recall who said that they wanted it changed.
Okay. And did you get some paperwork so that they could fill the paperwork out?
Yes.
Objection to the use of they.
Overruled.
You may answer.
I do have, yes.
Okay, next question.
During the course of the filling out of the papers, was there any more discussion about the price or anything like that?
There was never a question about the price. Lyle said that we don't like the carpeting and the wallpaper. There were many things they wanted to change. They were very concerned about the parking. Lyle was very concerned about the parking.
And with respect to the parking, was there some specifications as to the parking?
Yes, definitely.
What were the specifications?
They wanted something that was,
Objection to the use of they.
Yeah, if you could be more specific as to who said what.
thank you. Lyle wanted to be sure that wherever the parking was, that it was lit parking, that it was well lit.
How many parking spaces were requested?
Objection relevant.
Overruled.
2, that's all that's you can get, it's 2.
I mean, whoever was involved in this transaction or effort to purchase the condominium didn't negotiate a price with you?
No.
Whatever the price was that you were asking was the price that they agreed to?
That's correct.
Did you, on that first day, October 15th, did you ever see an attorney show up by the name of Goldberg?
No.
Was there discussion about a deposit?
Yes.
And how did that discussion take place? What was said?
Erik wrote the check.
Objection non-responsive.
Overruled. Is that the end of your answer?
Yes, Erik wrote the check.
No.
Was there any discussion about why he was writing the check or what was going to happen as a result of his writing the check?
Lyle asked him if he had a check, and he said yes. The only thing I recall is there was some concern as whether the amount of money was in the account.
Who expressed that concern?
Erik.
Okay, on that day, had you known that they were going to actually make the purchase of this penthouse?
Objection, cause for speculation, is also irrelevant. And the use of they.
Well, overruled. Did you expect anybody to come in and buy that condominium that day?
No.
Were there other people in line looking for that condominium?
Nothing further, Your Honor.
All right. Cross-examination.
Ms. Hart, directing your attention to Exhibit 137 in front of you, is that the paperwork that you referred to as having been filled out on October 15th?
Yes.
And that paperwork is in the name of Joseph Lyle Menendez, is that correct?
Yes.
There are in the papers spaces for the buyer of the condominium to sign as buyer, correct?
Yes.
And does the signature that appears in those spaces appear to be that of Joseph Lyle Menendez?
Yes.
There are in the papers also initials, or places for the buyer to initial various portions of the contract. Are those initials of Joseph Lyle Menendez?
Yes.
You sell real estate as for a business, correct?
Yes.
Is your expectation based on that paperwork that's before you that you had entered into some kind of a contract with Joseph Lyle Menendez?
Yes.
Okay, you didn't enter into a contract with Erik Menendez, correct?
That's correct.
His name doesn't appear on any of the documents,
No.
correct?
That's correct.
And you had in fact no enforceable agreement with him at all.
No.
Now, is your testimony today is that 3 people came and 3 people talked about liking this unit? Is that correct?
Yes.
Do you have any knowledge as to whether or not any or all of the 3 people were going to be living in this particular unit? That is, whether they were going to be co-tenants or roommates or anything else?
Yes. That, I assume that's what they talked about.
What do you mean, you assume that that's what they
Well,
talked
they
about?
talked about the 3 of them living there.
Is that an assumption, or you remember that?
I remember that.
And you have no knowledge as to who was going to pay the rent, or whether or not one of them might be tenants of the person who is actually buying the condominium. Isn't that correct?
Correct.
You have no idea as to what financial arrangements might have been made between the 3 people.
No, I don't.
One minute, if I may. If in fact 2 people are buying a unit, is it not appropriate to have both of them sign the purchase agreement?
Yes.
Thank you. I've nothing further.
All right, anything else?
Nothing else. Your Honor.
Okay, thank you. You may step down, wait out the hallway. Appreciate it. Did you wish to be heard further on this transaction?
Just that as the witness testified, they indicated that they liked the penthouse, that they wanted to make some changes, I believe, in the penthouse. And even though Erik Menendez's name does not appear on most of the paperwork, he did sign over the deposit.
All right, and did the defense wish to respond any further other than what we've already heard?
Your Honor, the issue is whether or not this is spending by Erik that somehow is relevant to what he was thinking in August or before August of 1989. I don't think, based on the record that is before the court, that this particular transaction represents spending by Erik and should be admitted against Erik in this capital case to show motive.
Just to backtrack for a moment to earlier discussion, since we've had other discussions on this subject and as to why the evidence is relevant, there was also another theory of its admissibility relating to the defendant's protestations in October and early November that the crime had not been committed for the money, and the defendant, Erik Menendez's statements of ambivalence at best and feelings of guilt perhaps that he had inherited as a result of the killings. And the evidence here is being introduced by the prosecution, not just to show what his state of mind was in August at the time of the killings, but also to refute the defendant's statements to Dr. Zoeller that he was ambivalent at best and feeling guilty at worst as a result of inheriting as a result of his father's death.
Your Honor, the prosecution introduced that evidence, so they're allowed to introduce it and then knock it down with collateral evidence of little probative value?
No, they're entitled certainly to introduce other relevant evidence on the subject. They're not bound by every word uttered by the defendants if there's other evidence to contradict it.
The problem here is this isn't purchased to begin with. It
Okay,
isn't.
I understand that part of it. So, all right, let me hear from Mr. Heffernan, and then we'll deal with both of these matters. And what I'd like to do, if there is this agreement regarding the stipulation, then the people indicated they would put on the evidence of Detective Zoeller before both juries, and then rest as to Lyle Menendez, so we can get that jury out of here, and then resume with the other jury. We'll hear this brief testimony, and then we'll proceed with that.
Raise your right hand.
Face the clerk and raise your right hand, please.
You do solemnly swear that the testimony you may give in the cause of any with the true words, the truth, the whole truth, and nothing but the truth, so help you God. Please take the stand and state your name for the record.
Mark Heffernan,
Spell your last name.
Heffernan.
Mr. Heffernan, in August of 1989, how were you employed?
By August of 1989, how was I employed? I was employed by the Menendez, both of the Menendez brothers.
Did you have other students of tennis? Were you the tennis coach?
Now, was this the time that I had the contract already?
No.
Before?
This is prior to the killings of the parents. Did
Okay.
you have some kind of connection to the Menendez brothers?
Yes, I taught them. They were part of my student load.
Okay. About how many hours per week would you teach Erik Menendez in particular?
2 to 6,
What was your hourly fee for tennis lessons?
$55 an hour.
Now, sometime after the murders or after the killings, did you have any discussions with Erik Menendez about full-time employment?
Yes, I did.
That is to the exclusion of all other students.
Yes.
And when did that occur?
To the best of my recollection, I think around October, November of that year.
Of 1989?
Yes.
How did the discussions between you and Erik Menendez occur regarding full-time employment?
You know, I'm not quite sure. At some stage, we talked about him being a circuit player, and then Lyle also entered into the negotiations about that, and we decided on a contractual arrangement verbally. I'm not sure exactly how long that took. I can't remember.
Did the initial discussions occur between you and Erik Menendez?
I would think they would have. I was with Erik more often than with Lyle.
Up until the point where you had the discussions about a contractual relationship, did you continue to teach both Erik and Lyle Menendez tennis at the $55 rate?
Yes.
Starting from October or November, as you've indicated, did you have a different arrangement with the increased number of hours that you worked?
Well, we had begun negotiations about a contract, and I think that we worked under the contractual agreement then, even though it took a long time to actually formulate the final contract.
Okay. Well, before the formal contract was finalized, while the negotiations were taking place, did you get paid the contract amount, that is the $5,000 in October, November?
I got paid before the contract was actually finalized. I'm not exactly sure when it started. I can't quite remember.
And at some point in January of 1990, the contract was signed, is that correct?
Yes.
And the agreement was that you would get $5,000 per month?
Yes.
And what were your duties under that service contract?
Are you asking in October, November, or afterwards?
Well, in October, November, what were your duties?
When I started working with them full time, which I did, I think at that time, I provided sort of sports science coaching services for them all day, 6 days a week.
And did you get paid on a monthly basis or bi-monthly basis? Or
Every 2 weeks.
every 2 weeks?
Nature.
I'm not quite sure who the check came from. It wasn't from the boy's personal account, I don't believe. It was either from the estate, or I'm not exactly sure. It's been a while, and I let that go in my distant memory, I think.
You received regular checks,
Every 2 weeks.
and you're not sure where you got the checks?
I'm not sure who, from what bank. It was from the East Coast, if I remember correctly. It was from New Jersey, I think. And I'm not exactly sure what company or what bank it was. It just wasn't important to me at the time.
Do you remember who signed the check over to you?
No, I don't.
You just, it had your name on it, so you cashed it.
Yeah, I put it in the bank. It wasn't a big concern for me. I've been cashing checks for a long time, and it didn't matter. It would have mattered, I think, more if they hadn't have gone through.
Right. Was there a reference on the actual check that this is for the services that you provided to Erik Menendez?
Overall.
I think I believe it stated for tennis services on the check. But again, I'm not really quite sure. It was a long time ago.
Okay. In other words, there's some kind of an indication on the check, I take it, if you got it from
Yes.
Check East, identifying it as paying for the services that you have rendered to Erik Menendez somehow.
Object, Your Honor. This Stacy's testimony. I think it would say-
Objection sustained. Why don't you rephrase the question?
Was there anything on those checks that you recall that indicated that it was for the services that you provided to Erik Menendez?
I don't recall.
Okay, thank you.
All right, cross-examination.
Mr. Heffernan, did you have a pre-existing arrangement with the Menendez parents for this hourly rate for coaching both Erik and Lyle?
Yes.
Did you have a November to November contractual arrangement with them?
No, it was like any other tennis student before the major contract started. It was, if I provided adequate services, they continued to hire me. I'm sure that's how they thought of it.
And you had been operating, strike that you had been providing tennis coaching services for a period of approximately 6 months before the parents were killed?
I think so, yes.
And when you say that you think the discussions about your becoming a full-time coach for both of them began, you say October, November, does that mean like end of October, early November, somewhere in there?
I would have to say around that time. I'm not exactly sure of the date.
Could have been even later?
It could have been. It could have been later. If I recall, I was paid a monthly fee a few months before the actual contract was signed because it took a long time in the signing and the final arrangements of the contract.
When the negotiating first began, okay, whenever it was Marta Cano, Erik and Lyle's aunt, involved?
I don't think when the first negotiation started, but she came in as the closer for their side.
And didn't Mr. Goldberg then come in as the second closer?
Yes, he did.
What were the original negotiations with the defendant, Erik Menendez, or with somebody else?
I think it was originally talked about with Erik and I, and then Lyle and Erik and I, and is to best of my recollection. And then the aunt wanted to get involved to help them with this negotiation.
How much were you being paid prior to the parents' death? You indicated you had an ongoing relationship with Erik Menendez. How many times a week were you teaching him tennis?
I'd say about 6 hours a week.
6 hours a week.
That's a rough estimate. I mean, whenever he was available and he wanted coaching, I would make my time available for him because he was a talented player, and I wanted to do that for him. So it varied week to week.
And during that period of time, the 6 months that you were coaching Erik, he was also in school at that time, was he not?
Yes, he was.
And he also was on the school tennis team.
Yes, he was.
And he was also having to train with them.
Yes, he did.
So he didn't have as much time to work with you as when he was out of school.
In the summer, we worked more often, yes.
And then for
Is
most
that
of
when you were working 6 hours a week during the summer or during the summer?
We worked a number of different hours a week, depending on the week and the situations. It was a very unique case. It wasn't like Tuesday afternoon at 3:30 I taught him. If he was available, sometimes when the school year was on, I taught him when he was playing for the school. If he got out of his school requirement with their tennis coach, I would work with him.
And when he was on vacation from school, would you spend more hours with him?
Yes, I did.
So over the course of that summer, didn't he travel most of the summer on the Junior National Tennis Tour?
No, it wasn't a junior national tennis
Well, the
tour.
national tour.
It would be, he played national tournaments and he played local tournaments.
Okay, but he was, are you aware of the fact that he was gone for most of the summer? From July 7th, say, to August?
Yeah,
9th?
he played a couple of national tournaments in a row and he went there early to prepare.
Now, did you participate in any discussions with Erik in which he was deciding whether or not to go ahead and go to college as he had planned before his parents died?
Briefly, I didn't have a lot of say in this. I think that was up to him and the family.
And was it your understanding that the college year for UCLA began in actually late August, early September?
That would be fair to say, I think.
So that by the time we're into the October-November period, it's long past the beginning of college.
Yes.
If you had continued under the previous arrangement of $55 an hour and worked with Erik full-time, isn't it true that it would have cost more money than what was negotiated under the contract?
Absolutely.
Did it appear to you, Mr. Heffernan, that Erik's family was involved in his decision-making concerning,
Objection beyond scope.
Sustained.
based on discussions you had with Erik and with family members, were they contributing to his decision-making on playing tennis full-time?
Objection beyond scope.
Sustained.
I have never heard of that.
Did anything change in your teaching or dealings with Erik Menendez as far as the amount of time you spent with him or the amount of money that he spent with you after the killings, his parents, than they had before?
After the killings, at some time in the fall, the contract was decided upon, and I started being paid even though the contract wasn't signed, to the best of my recollection. And before that, it was hourly like we had previously. And I'm not exactly sure of the timing there.
All right, but after the deaths of his parents, the number of hours you devoted to Erik Menendez changed as well, did it not?
Oh, it did. Once we started under our contractual agreement, we worked many hours a day.
Right, was he your exclusive student at that point?
Erik and Lyle both.
And you had no other students?
No.
And before that, how many students did you have?
15 to 25.
All right.
Mr. Heffernan, would you submit regular billing statements during 1989 before Mr. and Mrs. Menendez were killed?
Never.
Never?
No billing statements. I told them the number of hours I worked. I never wrote out a bill.
Well, let me show you something.
Okay.
I'd say never. May I approach the witness?
Yes.
Package of documents.
Without marking much, just show it to him.
Right, well, I'm gonna show it to you. Did you,
I wrote out some hours, but
yeah, let's basically all,
Okay.
you work at the California Graduate Institute
Yes.
Counseling Center.
yes.
Let me just show you this package of documents and ask them if it's a list,
Yes.
a listing that you gave of the number of hours that you coached
Yes.
Erik during
Mhm.
1989. These are separate
Yes.
listing of hours.
Oh yeah, you can. If this is probably what I did for them. For most of my clients, I didn't have to do this because it wasn't as extensive as 6 hours a week or 10 or 2 even.
Let me just show you a listing that's been done, and I'll just represent for the moment. We'll lay a foundation later that this is a compilation that we did from these billings. Let's see if this seems right to you. For example, December 15th, 1988 to January 10th, 89, it shows 15 hours of coaching for Erik. Then you can see January 11th to 17th, 12 hours. January 18th to 31st, 12 hours. February 3rd to February 10th.
That looks
8.5
perfect.
hours. Does that look about right?
Yes.
Okay.
Yes.
And there would be some weeks with a lot more and some weeks with less. Sometimes over a 2-week period, there'd be, so it would average out to anywhere from 6 to 10 hours, more or less.
Yes, that's fine.
Okay.
That's my signature.
Yes, it's your signature.
This is yours.
Yeah, just leave it there.
That's okay.
Anything else?
Do you know if at the time prior to the death of the Menendezes, they also had belonged to tennis clubs where there was coaching available?
They were coached in Calabasas, I believe, but I'm not sure how extensive it was, and I don't know the names of the clubs.
Was it your understanding that Erik and Lyle had both had professional coaches to some extent over the entire course of their tennis training,
Absolutely.
since the time they were little children?
I would imagine so. I know Jose worked with them a lot when they were younger, but I think they had coaches as well.
And that showed in the way that they played, did it not? That they had been
Yes.
professionally coached for many, many years.
It did.
Nothing further.
All right, anything else?
This national tournament which you referred to in summer of 1989, do you recall where that was?
It was in the South. It was the National Clay Courts. Tennessee, possibly. It was in the South.
Do you
Humid.
recall the approximate dates of that tournament?
I think it was beginning of August, if I'm not mistaken. End of July, in July or August.
Okay, and thank you. No further questions, Ray.
All right, you don't want to know if he knows whether NBC broadcasts. All right, thank you.
No, thanks.
You can just wait outside. All right, did council wish to argue the matter further? All right, nobody does. All right, let me inquire, is the stipulation agreeable now as to both sides on the Calabasas burglaries?
Wait a second.
I proposed a couple minor grammatical changes.
Have you run it past Mr. Burnett?
No, I haven't. I don't know. At least Kuriyama concurs. in
Okay,
that.
let Mr. Kuriyama review it for a moment here. What I'm trying to do is see if we can get this Lyle Menendez jury in as well. Ms. Bozanic, you're ready on both juries, is that right?
Yes, I have one question that I need to ask in front of the Lyle Menendez jury only, unless I can just ask it in such a way. What I want to ask Detective Zoeller is, did you go to Lyle Menendez's restaurant on March the 2nd, 1990 in Princeton, New Jersey? All right, so I'm gonna at one point need to ask that question of him outside, and then I can rest as
How
to.
long is the testimony before both juries?
I think it's going to take probably a half an hour, and I believe there's cross. Correct? There always is.
All right, I want to do that before we get
That's
to
fine.
this other evidence here. So if we're with understanding that there's going to be a stipulation, we'll start with this other evidence and then we'll deal with these other two issues afterwards. Keep those witnesses here until we've resolved
All right.
that.
All right, so should I?
We'll have the Lyle Menendez jury in first for
Okay.
that brief question and
question.
answer. And I assume there's no cross-examination on that one issue as to whether Detective Zoeller was at the restaurant.
No, there's not. There is one issue concerning the contracts for the condos that I think is only in front of the Lyle Menendez jury, and there's a separate contract that was not identified that I'd like marked and admitted concerning a condo that was purchased by the parents before the killing.
Okay, and you want to do that now or in your defense?
Well, I could do it now just because I thought she was going to allude to this area at some point. I'm not sure if full counsel has an objection to doing it in front of her jury. Putting in the contract for the condo that the parents
I have no
purchased.
objection to that.
I can do that in the joint cross-examination.
There is a 402 issue with respect to Detective Zoeller in front of the Erik Menendez jury, but we can wait until we get there.
All right, at this point then, let's, unless there is some need to further delay this matter, I want to get these jurors out of the jury room and into the courtroom. All right, so let's proceed then. We'll have to clear the center section here and get ready, and we'll have first the Lyle Menendez jury in and then the Erik Menendez jury. All right, Detective Zoeller is on the witness stand, and you're still under oath, Detective Zoeller.
Yes, sir.
And would you state your name for the record, please?
Leslie H. Zoeller.
All right,
Detective Zoeller, on the first Friday of March of 1990, did you go to a restaurant in the Princeton, New Jersey area?
Yes,
And was that the restaurant which was known to you as Mr. Buffalo's?
yes,
And when you went to that restaurant that day, did you go with anyone else?
I did.
Who did you go with?
I went with my partner, Detective Tom Linehan, and Richard Wenskowski, and his partner, John Aquaro, I believe is the spelling or the pronunciation.
It's Aquaro, is that correct?
Yes.
And while you were there, did you make any inquiries about Lyle Menendez?
No.
Okay. Did you make your presence as a police officer there known?
Yes.
Thank you. I have no further questions in front of this jury right now.
Any cross on that?
No, Your Honor.
All right, then we'll now have the Lyle Menendez, strike that, the Erik Menendez jury out as well, the blue jury, and they'll come into the jury box. And we'll now proceed with evidence being offered as to both defendants. All right, and the Erik Menendez jury is in court as well. And good afternoon to you. And again, I'll apologize for the delay, but give you a preview of what it's like when you are in the jury room during deliberations, at least as far as the confinement that you experienced during the deliberations. The fact that when deliberations start, 12 jurors will go into the jury room, and instead of talking about whatever you were talking about today, you'll start talking about the case. So I apologize for the delay, but there were things that the lawyers and I had to resolve, and we're now ready to proceed. We have both juries in the courtroom, and we have Detective Zoeller on the witness stand. You may examine the witness.
Detective Zoeller, when you first testified in this case, I believe one of the things you testified to was the collection of evidence at the crime scene. Do you remember that testimony?
Yes, I do.
And I put up a series of photographs that had some numbers that looked like printed numbers. And the three photographs on the board, which are 25, 26, and 30, are representatives of the photographs that you testified about when you first testified. Is that correct?
That's correct.
Now, I believe that I asked you questions about collecting wadding and pellets at the crime scene. And do you recall that testimony?
Yes, I do.
There were three items of evidence that were collected and numbered at the crime scene, which are depicted in these photos on the board, which were not wadding or pellets. Is that correct?
That's correct.
Number 7, which is shown up on that board, it looks like it's on some sort of blanket. Was that just a piece of white cloth that was collected?
Yes.
And that's exhibited in photograph 25. The next photograph, which appears to be of some sort of sofa or chair with a pillow in it, there appears to be a number 9 and a number 8. I'm going to ask you about just number 9. What piece of evidence is that supposed to depict in photograph 26? What does number 9 stand for?
Number 9 is the handheld portion of a cordless telephone, which you can see just the point of the antenna sticking out to the left of the pillow.
And so that handheld telephone was in fact found behind the pillow, which is depicted in this photograph 26. Is that correct?
That's correct.
And then the last piece of non-ballistics type evidence that was recovered is depicted in photograph 30. It has a marker next to it, number 16. And I believe there was some testimony about this, but that was just a piece of white plastic. Is that correct?
Yes,
And I think you testified earlier you thought it was part of a bracelet.
that's correct.
Now, moving ahead to another exhibit that I believe we've had some testimony about. This is exhibit number 19. It is a Xerox copy of some U.S. Sprint records. And I believe you testified previously that this is something that you came across in your investigation dealing with a phone call made from the Santa Monica Civic. Is that correct?
Yes, it is.
And this particular item, exhibit 19, has on it a phone number which was called from that area. Is that correct?
Yes, it is.
And counsel, will you stipulate that the phone number which is on exhibit 19, which is area code 213-657-8190, was Perry Berman's phone number on August the 20th of 1989?
Yes.
So stipulated?
Yes.
Thank you. I believe you've testified that on the early morning hours of August the 21st of 1989, you became the primary investigator into the deaths of Jose and Mary Louise Menendez, correct?
That's correct.
The following Friday, August the 25th, did you attend a memorial service for Mr. and Mrs. Menendez?
Yes, I did.
Could you tell us approximately what time of day it was and where it was?
I don't remember the exact time. I have an impression it was around the noon hour.
All right, so midday.
Yes.
Could you tell us where it was conducted?
It's on Sunset Boulevard in Hollywood at the Screen Actors Guild.
And do you recall seeing either or both of the defendants at that memorial service?
Yes,
How many were there? How many of the defendants?
both defendants were there.
Do you have a memory as to either one of them speaking to the audience during the memorial service?
Yes.
Your Honor, I'd like to approach.
All right, the objection is overruled. The answer will stand, but you may approach.
Detective Zoeller, do you have a memory of either one of the two defendants speaking to the audience at the memorial service?
Yes, I do.
And what is your recollection as to who spoke?
Eric spoke at the service.
And that was on August the 25th of 1989, is that correct?
That's correct.
Now, do you recall that in 1989 there was a Labor Day, correct?
Yes.
And do you remember what the date was of that Labor Day?
Yes, I do.
What was it?
September 4th.
And that was Monday, September the 4th?
Yes.
Your Honor, I have here two exhibits I'd like to mark as exhibits next in order. I think we're at 140 and 141?
Yes.
Okay, 140 is a copy of a life insurance policy along with an affidavit. And I have two copies of that. And also, Exhibit 141 is a copy of two wills, one for Mary Louise Menendez and one for Jose Enrique Menendez. I have two copies of each of those. Detective Zoeller, sometime during your investigation, did you become aware of the fact that there was a life insurance policy on the life of Jose Menendez with the Sun Life Assurance Company of Canada?
Yes.
Okay, and may I approach, please, Your Honor?
Yes.
Through various phone calls, did you cause a copy of that policy to be sent to the district attorney's office this year?
Yes, I did.
Counsel, would you stipulate that Exhibit 140 is a true and correct business record of the Sun Life Assurance Corporation?
Yes.
Yes.
And would you further stipulate that the information contained in the affidavit of Ms. Bonina is correct information?
Yes.
Yes.
Thank you. Just briefly, from looking at this affidavit, does it appear that approximately $325,000 was paid to each of the defendants as a result of this policy?
Yes.
In addition, I take it during your investigation, did you become aware of the fact that there was a will for each of the parents?
Yes, I did.
And the copies that I have here, Exhibit 141, does this appear to be a copy of the two wills that you were able to discern belonged with the Menendez estate?
Yes.
Counsel, will you stipulate that these two wills are in fact the two wills that were admitted to probate in the estate of Jose Menendez and Mary Louise Menendez?
Yes.
And just briefly, do these two wills leave the estate to the two defendants in the event that both of the parents are deceased?
Yes.
Detective Zoeller, on December the 5th of 1989, in the course of your investigation, did you go to the Menendez home at 722 North Elm Drive in order to retrieve a computer?
Yes, I did.
And were you present when Mr. Whitkin testified and identified a computer in a photograph, which I believe is photograph 63?
I was present.
All right. And did you, in fact, go into the same room identified by Mr. Whitkin on December the 5th?
Yes.
When you went into that room, did you take custody of the computer, which was in the master bedroom?
Yes, I did.
In addition to taking custody of the computer, did you find a document there while you were taking the computer?
Yes.
And could you tell us briefly what the document was?
The document was the receipt of Howard Whitkin with his company name, and I located it on top of the television in that room.
All right, may I approach, please, Your Honor?
Yes, we have again, is this September or December 5th?
This is December the 5th, I'm sorry.
Is that right? December the 5th?
That's correct.
Right, now I'm going to show you Exhibit 64, which appears to be an original receipt. Is that the receipt that you took from the master bedroom?
Yes, it is.
And I'm just going to briefly show you photograph 63, which is fairly small. That is the photograph about which Mr. Whitcomb testified.
It is.
And that is the room in which you seized the computer, which is located at the far corner of the room.
That's correct.
And this receipt, Exhibit 64, where was that within the room?
It was located on the television, which is depicted on the right side of the photo, approximately in the middle of the photo.
Okay, so there's a large TV, it looks like at least a 27-inch TV about, and there's a VCR on top.
That's correct.
And where was this Exhibit 64, the computer receipt?
It was either on top of the television or on the VCR, which is on top of the television.
And after you found that receipt, did you in fact contact Mr. Whitcomb on the 11th of December of 1989?
That's when I first interviewed him, was the 11th.
And that was the first time you knew who he was? Or did you know about him a couple days before?
I knew about him a couple days prior.
Detective Zoeller, did you ever find any shotguns which were affiliated with this case? Did you ever find the two shotguns?
No.
Sometime during the first full week of March of 1989, did you meet a woman named Judalyn Smith?
Yes, I did.
And subsequent to that, did you write and execute a search warrant at the home of Dr. Oziel?
Yes.
Now, after you spoke to Ms. Smith and you went to Dr. Oziel's home, did you make an effort to locate a store where shotguns had been purchased?
Yes, I did.
Prior to meeting Ms. Smith and the execution of the search warrant, had you made any efforts to locate shotguns? The
Yes, I
purchase of
did.
pardon
Yes,
me.
I did.
And briefly, without going into a blow-by-blow account, could you tell us what efforts you made before that time to find the shotguns?
First of all, I contacted Department of Justice, which is the governing agency for federal firearms licenses in the state of California, and I asked them for gun stores in an approximate 10-mile radius around the city of Beverly Hills and Calabasas. I got a printout of those stores, and I proceeded to go to those stores, interview, and go through their gun records.
And I take it that search was fruitless, is that correct?
That's correct.
After speaking with Ms. Smith and after the execution of the warrant, did your search lead you to the San Diego area?
Yes, it did.
And when you went down there, did you have a list of stores, again, provided by the Department of Justice?
Yes, I did.
And did you concentrate your efforts in locating the store where the guns had been purchased?
That's correct.
How many days did it take you before you found the information?
2 full days with 4 investigators working on it.
And could you tell us how it was that you came to the Big Five store about which Miss Amanda Adams Geyer testified?
Just one of the stores on my list, and I just went into the store.
And what did you do? What did you ask them?
I asked them to explain my investigation and asked to review their gun records.
Okay, now when you talk about the gun records, were those the gun records about which Miss Geyer testified?
Yes, it is.
And in going through the gun records, did something catch your attention?
Yes.
What caught your attention?
The receipt with Donovan Goodrow's name on it, purchasing 2 shotguns.
And at that time, you had already been apprised that Mr. Goodrow was a friend of Lyle Menendez, is that correct?
Yes.
So you recognized the name
Yes, I did.
and you seized those records?
Yes.
Your Honor, I have Exhibit 52. I'd like to approach, please.
Yes.
Exhibit 52 contains, I believe, 3 pieces of paper, but they're marked as 4 because one of them has a backside. Are these, in fact, Exhibit 52A through D, the records that you seized after your second weekend in San Diego, or your second day in San Diego?
Yes.
Now, approximately how many gun stores in the Los Angeles area did you visit before your search led you down to San Diego?
I don't know an exact number. I would just be guessing.
Well, was it more than 10?
It was close to 100 stores.
And when you went to these stores, were you limiting yourself to a certain area? In other words, were you trying geographically, were you limiting yourself?
Yes.
And were these stores that sold shotguns?
Yes, they were.
Did you not go to stores, and did you eliminate stores that didn't sell shotguns?
To the best of our ability before we traveled there, yes.
After you found Exhibit 52 with Donovan Goudreau's name on it, did you attempt to locate the address which was listed in that document, which was 63 August Street?
Yes, I did.
And what did you do? Did you have a Thomas guide?
First of all, I had a Thomas guide and looked up the street,
And did you actually go to the street?
and I went to the street of August Street in San Diego.
Did you see an address of 63 August Street?
No, the only 100 block that they had of August Street in San Diego was the 5,000 block.
When you went to San Diego, well, you've lived in Los Angeles for a while, correct?
That's correct.
With the best traffic conditions, how long does it take to drive to San Diego from the Beverly Hills area?
Approximately 2 hours.
Now, after you found the gun records in this case down at the Big Five store in San Diego, did you ever locate the shotguns?
No, I did not.
On March the 8th of 1990, some several months after you first were assigned to this case, I believe you testified that you participated in the execution of a search warrant at Dr. Zoeller's home. Is that correct?
That's correct.
At that time, were tapes recovered from a safety deposit box?
Yes, they were.
And when those tapes were recovered, were they handled as pieces of evidence in a certain way? In other
Yes,
words-
they were.
All right. And could you tell us what happened to those tapes after they were seized?
Well, they were seized as confidential recordings or pieces of evidence, and they were taken immediately into the possession of Gary Mogul, who was the special master.
Okay. Could you tell the jury what a special master is briefly?
We can object to this, irrelevant.
A special,
Could I ask a leading question then?
Yes.
Is a special master someone who attends a search warrant in special situations?
yes,
And did he, in fact, have control then of the tapes after they were seized?
yes, he did.
In addition to having control of the tapes, did he also take control of exhibits 97, 98, and 99? And I'll show them to you so you know what they are. 97 are various ledger pages about which Dr. Zoeller testified in requesting, correct?
That's correct.
And then 98 and 99 are appointment books for the years 1989 and 1990. Is that correct?
That's correct.
And as well as the tapes that you've testified to, did Mr. Mogul also take custody of these items, 97, 98, and 99?
Yes, he did.
To your knowledge, from the home or from the location where these items were seized, were they then taken to court?
Yes,
And they were not in police custody, is that correct?
they were never in police custody.
Now, the first time that you had access to Dr. Oziel's tape from October 31st and November 2nd, could you tell us what month and year that was?
Your Honor, I'm going to object.
All right.
So, Detective Zoeller, on March the 8th, the tape and the appointment books and the ledgers were all taken by Mr. Mogul to the courthouse, is that correct?
That's correct.
Now, on March the 8th, was Lyle Menendez arrested for the murders of his parents?
Yes, he was.
And in the early morning hours of March the 11th, 3 days later, was Erik Menendez arrested for the murders of his parents? Or was it the 10th? The early morning hours of the 11th.
Yes, that's correct.
Thank you. I have no further questions.
All right, cross-examination.
Detective Zoeller, as to the photographs that are behind you there, what is item number 8, which is depicted in the photograph in the center and the board next to you and the one in the middle in the board next to the jury that's in the audience.
It's an individual pellet, which is just to the left of the stanchion that has the number 8 written on it.
And is it true that on the night that you were at this scene, that you were the one in charge of supervising the collection of the evidence?
To a broad sense, yes.
And in the broad sense of documenting where it came from and writing up the reports that documented the specific locations where the items were?
No, I did not do that.
Did you prepare a report which indicated the items of property that were taken from the residence that night?
If you could show me the report,
Sure.
please.
I've had Marta on her as exhibit number 142, set of documents entitled Evidence and Property Record. Did I approach you with Michelle?
Yes,
Showing you exhibit 142, do you recognize that document?
I do.
And could you tell us what that is?
It's, as it's labeled, it's an evidence and property record.
And does that record accurately record all the items of evidence that were seized from the Menendez residence on August 20th, 1989?
To my best knowledge, yes.
And are there other documents in that package?
All pertaining to the same collection of evidence.
In other words, that packet of documents accurately reflects, number one, the items that were taken by you or people working under you that night, correct?
Correct.
And it also accurately represents where they were taken from in the room.
That's correct.
There are measurements in there that indicate accurately where each item was taken, correct?
That's correct.
Including the items that are depicted in the photographs that are behind you.
Yes.
Is that right? Now, turning your attention to the two wills, that's exhibits 141 and 142.
Yes.
Who was named as the executor of each of those wills?
I'd have to review them again,
Do you
please.
have those in front of you?
I do not.
Perhaps you can point them to the paragraph.
Let me answer your question.
Yes.
Carlos and Teresita Peralt.
And is there also in each of the wills a provision that Lyle Menendez could be named executor of each of the wills upon his turning age 22?
That's correct.
And where did you, if you did, obtain those wills from? Did you physically get those from someone?
I physically got them. I'm not sure whether I got them from Mr. Goldberg, who's an attorney for the estate, or whether they were given to me by Mr. and Mrs. Peralt.
In other words, you interviewed both Mr. and Mrs. Peralt and the executor for the estate,
That's correct.
and either one or the other gave you a copy of those wills, correct?
That's correct.
And you read the wills, I take it?
I did.
And at some point, did you obtain any documentary evidence to indicate that Lyle Menendez exercised his rights under the will to become the executor?
I received no such information.
To your knowledge, does any such information exist?
Not to my knowledge.
Now, I think you said on December 5th, 1989, you took possession of the receipt from Howard Whitman, correct?
That's correct.
And you interviewed Howard Whitman on December 11th, is that true?
That's true.
Is it true that the day that you obtained the document from the Menendez residence with Howard Whitman's name on it, you had a search warrant in your possession?
That's correct.
And that was a search warrant authorizing you to go into the Menendez home and seize evidence of the computer and any documents such as the receipt with Mr. Whitman's name, correct?
That's correct.
Did you obtain that search warrant on that day, that is December 5th, 1989?
I did.
And you obtained that search warrant after an article was written in the Los Angeles Times on that very morning, correct? Indicating that there was some suspicion by members of your department that there was a problem with the will.
That's correct.
And that article in the Los Angeles Times would have been published the morning of December 5th before you obtained the search warrant?
That's correct.
And is it true that on the same morning after that article was published that you received an anonymous call from someone who apparently had read the article and said they had been,
Objection, Your Honor, calls for hearsay.
this goes to his state of mind for the non-hearsay purpose of showing what he did
Then it's
after
irrelevant.
receiving the information?
The objection is sustained. The issue is what he did, not what information he had. Objection is sustained.
Did you receive, without going into the content of it, did you receive an anonymous call after that article appeared in the Los Angeles Times on December 5th?
I did.
And did the article itself indicate that your department was investigating the possibility of a second will being erased?
Yes.
And as a result of that article being published, did you feel it was important on that day to get a search warrant for the Menendez home?
Yes.
And did you, when you interviewed Mr. Whitkin later on the 11th, find out that he had been in the Menendez home on August 31st, 1989?
Yes.
And when you went to serve the search warrant on December 5th, did you find the receipt in plain view on the top of a television right next to the computer where Mr. Whitkin later told you he had been working?
It wasn't exactly right next to it, but I found it on the television probably 10 to 15 feet away from the computer.
And it was in plain view, was it not?
It was.
In other words, you didn't have to tear the house apart to find it. It was right there on the top of the television.
That's correct.
Said at some point you went to San Diego and retrieved the gun records, correct?
That's correct.
And in the store where you retrieved those gun records, were there surveillance cameras?
Yes.
And were those positioned above where the gun counter was?
Yes, they were.
You testified to various documents that you retrieved in the case, including the wills, correct?
That's correct.
Did you also at some point retrieve two purchase agreements which had previously been marked as exhibit number 56 and exhibit number 57 for two condominiums in New Jersey?
That's correct.
And do you remember when you received those documents?
I don't remember the date.
And I've had Marcus defendants next in order a purchase agreement and a cover letter dated March 29th, 1990.
That's exhibit 143.
Detective Zoeller showing you exhibit 143. Do you recognize that document?
I do.
Is that a cover letter that you received in the mail along with a purchase agreement which is attached to that for another condominium in New Jersey?
That's correct.
And is that a condominium that was purchased by Mr. and Mrs. Menendez sometime in July or August of 1989?
That's correct.
And lastly, Detective Zoeller showing you what has been marked exhibit number 144, which is a photograph, and exhibit 145, which is also a photograph. These two photographs accurately depict the interior of the Big Five gun store where you retrieved the gun purchase records that you've testified about,
Yes.
showing the placement of the surveillance camera.
Yes, that's correct.
Thank you. That's all I have.
Cross-examination on behalf of Erik Menendez.
I want to put up those photographs.
Why don't I ask you first to look at 145? And it doesn't appear from that photograph that the surveillance camera in the Big Five in San Diego points at the gun counter.
Yes,
And did you, when you were at this location, determine whether or not those cameras were meant to record gun purchases?
yes, I did determine that.
Now, when were these photographs, what month and year were these two photographs taken by yourself? You don't remember?
No, I took our photographer down to take them.
Okay. When were those photographs taken?
Again, I'd have to guess. It was after we obtained the gun records. I'm going to guess and say approximately 2 months afterwards,
May, perhaps,
perhaps.
but they were not taken in August
Of which year?
of any year.
That's correct.
Okay, so they were not taken at the beginning of the game hunting season, which begins in
That's
end of
correct.
August. Were you aware during the week of August 21st to August 26th that various members of the Menendez and the Anderson families were in Los Angeles?
Conviction Vegas to which year?
1989.
I can only state that I know they were, that's a correct statement.
You did know they were here.
Yes,
And at the memorial service that you attended on Sunset Boulevard, did you meet and talk to members of the Menendez and the Anderson family?
no,
You didn't contact anyone there?
no, I did not.
Did you see Dr. Oziel there?
I didn't know who Dr. Oziel was at that time, and I saw a lot of people. I don't know whether I saw him or not because I didn't know who he was.
Did you, prior to the memorial service, meet with any of the family members either at the Elm Drive residence, at the Bellage Hotel, or at the Bel Air Hotel?
Could you repeat the question as far as,
I'd object to this being compound and ask it to be broken.
All right, why don't you rephrase it?
Did you meet, first of all, did you meet with or talk to any of the Menendez and Anderson family members during that week of August 21st through August 26th, 1989?
yes,
And did you meet with any of these persons at the Elm Drive residence? Obviously excluding Erik and Lyle Menendez, okay?
at the Elm Drive residence, that's correct.
And do you recall who you met with there?
The only ones I can recall are Teresita Baralt, Carlos Baralt, and Maria Menendez, the grandmother.
Did you meet with or see any of the members of the family at the Bellage Hotel where they were staying?
I don't believe so, no.
Did you meet or see any members of the family at the Bel Air Hotel where they were meeting?
No,
Did you see any of them at the Beverly Hills Police Department?
in that period of time, I don't recall. I know that Carlos Baralt came to the police department, I believe, one time.
As of Labor Day, September 4th, 1989, were you already acquainted with Craig Signorelli?
Yes,
Had you left him a business card or some method by which to contact you when you made his acquaintance?
whether it was a business card or just give him my name and number, I did give him some method to get hold of me.
Thank you. Were you aware of the memorial service and funeral that was held in New Jersey?
Yes.
And do you know what day that was?
I believe it was the following Sunday,
Following what?
following the deaths and following the Los Angeles memorial service.
So it would have been the 29th? The 27th?
I believe so.
Did you attend the memorial service in New Jersey?
I did not.
Did anyone from your department attend?
No.
Were you aware of the fact that Erik and Lyle had left Los Angeles to go back to New Jersey
At what point?
prior to that memorial service in New Jersey?
Yes, I was aware of that.
Were you in contact with Erik or Lyle while they were in New Jersey after August 25th? Between August 25th and Labor Day?
No, I was not.
Were you in contact with any members of the family between August 25th and Labor Day?
Other than the phone?
No, even including the phone.
I don't believe so, no.
You indicated that you looked for shotguns, not for shotgun purchases, but for actual shotguns. Is that correct?
That's correct.
And when did you first look for shotguns?
The exact date I don't recall. It was after the 8th of March of 1990.
When was it that you conducted this survey of gun stores within a 10-mile radius of Beverly? You mean, I guess, a 10-mile circumference around Beverly Hills?
That's correct.
Okay. When was it that you conducted that canvass of gun stores?
Between September of 89 and February of 1990. I don't have an exact date. It actually was a long, involved process that took many weeks.
You arrested Erik Menendez on March 11th, 1990.
That's correct.
Where did you arrest him?
At Los Angeles International Airport.
And was he, did you know he was going to be there? Was there an arrangement for you to meet him?
Yes, there was.
And was it your understanding that he was flying in from Europe to surrender to you?
Objection calls for hearsay.
Overruled.
That's correct.
You did not have any kind of extradition warrant for him or any extradition proceedings to bring him back from Europe, did you?
No,
He came voluntarily.
that's correct.
It was your understanding that at the point when Lyle was arrested, Erik was in Israel. Is that right?
That's correct.
And has Erik been in custody from that moment that you arrested him on March 11th, 1990 to this moment?
Yes.
I might have a moment. When you arrested Lyle Menendez, where was he physically?
I didn't physically arrest Lyle Menendez.
Other members of the Beverly Hills Police Department did?
That's correct.
Wasn't it, as the investigating officer, are you aware of where he was arrested?
Yes.
And wasn't it in Beverly Hills?
He was leaving the residence in Beverly Hills, yes.
The Elm Drive residence.
That's correct.
I have nothing further, Your Honor.
Any redirect?
Yes, just a moment. Just a couple questions. Detective Zoeller, the property report that shows the collection of evidence which the defense marked as Exhibit 142, was that prepared by you or by someone else?
By someone else.
And you were asked by Mr. Bird if to your knowledge, Lyle Menendez had ever exercised his right to be the executor of the estate. Is that correct?
That's correct.
To your knowledge, were portions of the probate file sealed?
I have no knowledge of that.
You indicated that you went to a memorial service on August the 25th of 1989. Could you give us an approximation of how many people were at the memorial service?
I'm going to guess 100 to 200 people.
All right. And you were asked if you actually looked for the shotguns. Could you tell us what measures you took to actually go and locate shotguns, in this case, the physical shotguns?
With a group of officers from the Beverly Hills Police Department, we looked on either side of Mulholland Drive from approximately 1 mile east of Coldwater Canyon to approximately 5 miles west of Coldwater Canyon.
How many occasions have you gone up to Mulholland Drive looking for the guns?
Myself and other officers approximately 5 times.
And did you go as recently as this spring to look for the guns?
No.
Did you go to an area where some new houses are being built this spring?
That's correct.
And did you again look for the shotguns?
Yes.
Thank you. I have nothing further.
Anything else?
I just have one question. Where are new houses being built?
On Mulholland.
Well, it's not on Mulholland. It's an area at the end of, I don't remember the street, whether it's a new development that goes to the backside of the development to Mulholland. It might be San Ysidro.
How far east or west of Coldwater is this area?
It's approximately a half mile west of Coldwater.
Okay, thank you.
All right, if council would approach briefly here.
Your Honor, could I ask the district attorney one question?
Sure.
I have one more question.
All right.
Detective Zoeller, I believe you were asked on cross-examination about the cameras that are depicted in the photographs which have been marked by the defense.
That's correct.
Okay. And I believe you were asked to make a determination about them, but nobody asked you what the determination was. Could you tell us what the determination was about those cameras?
Well, Your Honor, object to the question.
Yeah, nobody actually asked what happened with those cameras or whether pictures were taken, anything of that nature. So
Well, let me
you have
ask
to
him.
go into that, please.
Let me ask him.
I assume that's what you're asking.
Yes, Detective Zoeller, did you know whether those were real cameras or fake cameras?
Yes, I determined that they were fake cameras.
Thank you.
All right.
Is there a sign on those cameras for the customers that says, these are fake cameras, we're not really taking your picture?
No, there is not.
Okay, and in looking at them from a layman's perspective, they look real, don't they?
That's the purpose. That's correct.
Did Big Five explain why they don't have real ones?
No, they did not.
We think they're just too cheap or something? Okay.
All right. Anything else?
No.
Okay, council, why don't you approach here and we'll discuss scheduling. All right. At this point, what I'm going to do is excuse the Erik Menendez jury for a break of 10 minutes, 20 minutes to the hour, if you would return to the jury room, and hopefully by then we'll be able to proceed. Don't discuss this case with anyone. Don't form any opinions about it. And we'll resume with you in just over 10 minutes at 20 minutes to the hour. And we're going to remain in session here with the other jury for a little while. And so as soon as you leave, we'll continue on with our other matters here. We still have the Lyle Menendez jury in the courtroom and the defendants in court as well. Any further evidence to be offered by the prosecution?
Not at this time, Your Honor. The people of the state of California rest their case as to defendant Lyle Menendez.
All right, subject to the receipt of physical exhibits, the people rest. And therefore, as to the Lyle Menendez jury, what I'm going to do is excuse you until Monday at 10 a.m. and ask you to return to this courtroom or to your jury room at that time, and we'll be ready to proceed the defense portion of the case. It's very important at this point, as it has been throughout the trial, that you not discuss this case among yourselves or with anyone else, not form any final opinions about it, and not permit yourselves to be exposed to anything related to this case outside of the courtroom. Remember, you must make your decision in this case based only on the evidence presented to you in the courtroom and my instructions on the law. Wish you all a good weekend and ask that you return Monday at 10 a.m. All right, the jurors have left. There are still some evidentiary matters relating to the defendant, Erik Menendez, and specifically those areas that have been the subject of litigation today. These were matters that were presented to the court to permit the court to exercise its discretion under Section 352 of the Evidence Code to evaluate the evidence and determine whether the probative value of this evidence substantially outweighs any prejudicial effect or potential for undue consumption of time or confusion of issues. And the court has already ruled upon the evidence relating to the hotel accommodations immediately after the August 21st events. And the court has also ruled in relationship to the purchase of an automobile by the defendant, Erik Menendez, and also has ruled in regards to the purchase of certain jewelry items shortly after the events of August 20th and 21st. And now the two remaining items relate to the evidence of purchase or attempt to purchase a condominium, and also the evidence relating to tennis instruction. First of all, in regards to the tennis instruction, there is evidence presented that the nature of the relationship between the defendant and Mr. Heffernan changed, the instruction level changed, the relationship in regards to compensation changed after the killings, and it was different after the killings than it was prior to that time. There is probative value in that, that the defendant changed his lifestyle in regards to his goal as far as his career goal or goal to whatever his personal goal was in regards to this relationship with Mr. Heffernan. And it was in close time proximity to the time the deaths occurred here, and the circumstantial evidence of the defendant's state of mind, and the court finds that the probative value of that substantially outweighs any potential prejudice or undue consumption of time and or confusion of issues, and the court will permit that. In regards to the purchase of the condominium or attempt to purchase the condominium, that evidence is ambiguous to some extent in that the records of the transaction relate to Lyle Menendez, his name on the documents, and we all are certainly aware of the legal obligations and the rights of the parties involved, and that other than some side agreement between Lyle and Erik Menendez, the contract itself was only between Lyle Menendez and the Marina City Club. The evidence also, however, is that the defendant, along with Lyle Menendez and another individual, discussed accommodations and discussed living at that particular location and discussed residing in that particular dwelling. And it wasn't discussed, as the evidence has been presented to me, it wasn't discussed as exclusively the accommodations or the residence of Lyle Menendez, but Erik Menendez as well. And whether there was some side agreement that this was a loan or some other arrangement between Lyle and Erik Menendez, the fact remains that when money was to be put on the line, it was Erik Menendez who did it, and it was a substantial amount of money. And it was done, again, within close proximity and time to the time the crimes occurred. And the court finds that again, the probative value of that evidence is substantial, and using the analysis under Section 352 of the Evidence Code, the court finds that the probative value substantially outweighs any potential prejudice or confusion of issues or potential to mislead the jury, and therefore the court will permit that evidence as well. All right, we'll take a recess and we'll resume in 5 minutes with both juries, or with the Erik Menendez jury, rather. Defendants in court with his attorneys, people represented. Is there something that you want to discuss?
I just needed a ruling on whether the leasing is also admissible.
Are the people pursuing that?
Yes, I believe the defense will bring out that the purchase agreement was not consummated. They didn't actually go through with the purchase, and he ended up buying or leasing a condominium at the Marina City Club for $2,450 per month.
When?
November 9th, I believe. I've given the documents to counsel.
Just for the record, John, I don't object to their bringing out that you leased one, it's just the amount of money that I think is irrelevant. Particularly since Noel Medley, the owner of the company. Noel Medley, N-E-D-L-I.
Yes, signed November the 17th of November, 1989.
All right, at this point, I don't find that the value of the amount of the rent is a substantial probative value, and I'll not permission to go into that. It might be relevant during the defense. I don't know how the defense will present its case or the examination of the defendant, but at this point, the amount of that rent doesn't seem to have any relevance.
Very well, Your Honor.
All right, are we ready to proceed? You have your stipulation as far as the burglaries, and how are you proceeding with the BBC evidence?
Your Honor, what I had intended to do is call Heffernan, Hart, put on a stipulation regarding the Bird Jeep and Eagle purchase of the Jeep by Erik Menendez, and then put on Detective Zoeller for the BBC movie information, and also some statements that he heard on 11/29/89, and then get into the Calabasas burglary stipulation. Whether or not we're going to finish all of that today, I don't know, but I'd like to put on Heffernan and Hart right now.
All right.
We need a four-inch on Detective Zoeller because you know what that conversation, that's the Craig Signorelli conversation.
Well, it was a couple hours long. I know it. I don't know what it is that they're trying to bring out. Oh, we'll talk about that later.
Okay.
Let's get to the witnesses and the jury.
Okay, thank you, Your Honor.
All the jurors are back in court, and we'll now resume with evidence relating to Erik Menendez. You may proceed.
Thank you, Your Honor. People call Mark Heffernan.
Please raise your right hand. You solemnly swear that the testimony you may give in the trial containing the court will be the truth, the whole truth, and nothing but the truth, so help you God. Please take a stand and state your name.
Mark Heffernan,
Please raise your hand.
Hefffernan.
Thank you, Your Honor. Mr. Heffernan, in 1989, did you make a living teaching tennis?
Yes, I did.
And toward the beginning of 1989, did you?
Yes.
Mr. Heffernan,
Toward the beginning of 1989, did you become the coach of Erik and Lyle Menendez for tennis?
Yes.
Approximately how often would you teach Erik Menendez per week?
Up to 6 hours a week,
And what did you charge per hour?
$55 an hour.
On August 18th, 1989, did you teach or did you have Erik Menendez as a student in a lesson?
Yes, I believe I did. Yes, I did.
Okay. Do you recall the time period that Erik Menendez had a lesson on that particular day?
I believe it was in the morning between 9 and 12. It was 2 hours, either 9 to 11 or 9:30 to 11:30.
You became aware of the killings of the parents a couple of days later, is that correct?
That's correct.
Now, after the killings of Jose and Mary Louise Menendez, did your relationship with Erik Menendez change with respect to the coaching that you did?
Well, there was a delay. There was a mourning period, and there was a lot of time with the family, and I had to respect that time. So there was a number of weeks, I believe, that they were going through the mourning period and also going back to New Jersey, if I remember correctly.
Sometime in October, did you resume lessons with Erik
Yes.
Menendez? And sometime in October or early November, did you have any discussions with Erik Menendez about full-time employment?
Yes, I did.
And would you relate for the jurors what the nature of the conversations were between you and Erik Menendez?
At that time, we thought of Erik going on the professional tennis circuit at the satellite level, and developing him as a professional tennis player.
And did you have direct discussions with Erik Menendez about being contractually bound to him exclusively?
Yes, I did.
At some point, did you then arrange with Erik Menendez to teach him exclusive to any other student?
He and his brother.
Okay.
Yes.
Now, how many students did you have at that point?
I believe between 15 and 25. It varies. It's a fickle business.
Now, at some point, or do you recall when it was that you started to put in full-time employment for Erik Menendez and his brother Lyle?
I would assume it was around the 1st of November. I'm not exactly sure of the dates.
And how much money were you getting paid?
I was getting paid $5,000 a month for one boy, or $6,000 for two if I worked with both of them.
Okay. With respect to Erik Menendez, what was the agreement? How much would he have to pay you per month?
$5,000.
How much time would you spend with Erik Menendez?
I would spend all day with him. 5.5, 6 days a week.
How many hours would that be per day?
8 to 10.
And had Erik Menendez requested this arrangement?
Erik and Marta, his aunt, and the contract was decided upon between the brothers and Marta and myself.
Was there a period of time that Lyle Menendez was also involved in this arrangement?
Yes, he was.
How long a period of time was that?
Basically the fall and until after the new year, I believe. But right after that, he got involved in business ventures, and he basically left and did those, and I worked with Erik exclusively.
Okay, and you believe that occurred about the beginning of 1990?
I think so. The dates are fuzzy. The time elements I'm not exactly sure of. But.
From that point on, then it was just an arrangement that you had to coach Erik Menendez exclusively?
Yes.
Nothing further, Your Honor.
Mr. Heffernan, your original contact with the Menendez family was in 1988, is that correct?
I believe it was.
And prior to the death of Erik's parents, had you been coaching him for about 6 months?
I think so. Yes.
And during those 6 months, was Erik attending Beverly Hills High School?
Yes, he was.
And was he on the Beverly Hills High School tennis team?
Yes, he was.
And was he training and being coached at the high school as well?
He was training at the high school. I don't know about the coaching, but he was training.
Okay, and there's a high school coach for the high school team, is that
Yes.
correct? And he would play in matches for the school, is that
Yes.
right? Now, he was also playing, to the best of your knowledge, in matches that were part of the United States Tennis Association authorized competitions.
Yes, he was.
And so over the entire course of a year, he would compete in different matches.
Yes.
And apart from the times that you were coaching him, were you aware of the fact that he was also practicing on his own?
He was practicing at the school nearly every day. 5 days a week, he'd have practices after school, except if he got an exemption to play with me.
So he'd either practice after school at the school or he'd practice with you
Yes.
during school days.
Yes.
Was it also your understanding and your observation that he would practice on the weekends?
Absolutely.
All day on the weekends?
No.
And was it also your understanding that he would have matches to practice with other young men besides practicing with you?
Yes.
When you would coach Erik, would you do it at his home?
Nearly exclusively at his home.
They had a tennis court at the house.
Yes, they did.
And when you would, and we're still talking about that period of time before his parents died. When you would coach him at the home, if Mr. or Mrs. Menendez were at home, would they observe what you were doing?
Most of the time they would. Especially Jose. He wasn't there often, and when he was home, he always watched. Or I can't say always, but quite often.
When, in 1988 and 1989, before August 20th, who paid you for the lessons?
The mother.
And your rate was $55 an hour, correct?
Yes.
And were there some weeks when you would spend more time, give more hours of coaching to Erik, and other weeks when you'd give less?
Absolutely. Yeah.
And would that depend on, first of all, whether he was in town versus traveling in tennis matches?
In town and his schedule in general. I mean, it was all up to him. If I was available, I would coach him. If he had things to do, it was variable week to week.
And basically, you were fitting your coaching in around his school time, correct?
Yes.
He was in school full time, as far as you.
Yes, he was.
Now, did you also in 1988 and 1989, before August 20th, give lessons to and coach Lyle?
Yes, I did.
Was Lyle a more talented tennis player than Erik?
Lyle, I would have to say, was at the time. He was more mature physically, and I would assume mentally and emotionally, and he'd been training longer. Their ultimate developmental level, I think they could have each risen to the same place given a serious amount of training.
And how high a place did you think they could have each risen to given a serious amount of training?
Well, I think at some level they could have been professional tennis players. Now, it's hard for me to extrapolate down the road where they could break through. They could have been world class. In the top 50 or 100 players in the world, depending on the seriousness of their intent. But that was hard to determine.
Okay. Is it hard work to become a professional tennis player?
Very.
Does it take a lot of exertion and stamina and hours and practice and physical pain?
Absolutely. Mm.
Now, after Mr. and Mrs. Menendez died, you said there was a period when you were not coaching Erik, when he was in mourning and he was spending time with his family, and he didn't contact you for coaching. Is that correct?
That is correct.
And did you see Erik during that period?
Yes, I saw him a few days after the killings at the Bel Air Hotel, briefly. And then I saw him in New York City. I was at a national coaches convention in Manhattan, and he happened to be there for the U.S. Open, watching the U.S. Open, and he came to my hotel and saw my wife and I,
And did he appear to be in mourning?
yes, he did. Mm-hmm.
Now, at some time in October, you started having discussions with Erik and his Aunt Marta,
Yes.
and those discussions were focused on whether Erik should try to become a professional tennis player, or at least try to get involved in the professional tour.
Yes, he was very interested in doing that.
Now, this kind of tennis training that's required for that professional tour, is it very structured?
I tried to make it structured. I don't think that a young athlete now, especially with Erik's history, he wasn't coming from being the best junior tennis player in the country. So he had to have it more structured in order to have a chance to really develop. That was my impression.
So you were designing what could be called a highly structured program for him?
Very.
Did he express to you, after his parents died, a need for structure, a need for order and stability?
I don't think he expressed that to me. I felt it.
And so strike that. Isn't it true that there were a whole series of discussions and negotiations between yourself and Erik and Aunt Marta and Lyle prior to the signing of the contract that you've testified to?
Yes, there was. That's fair to say.
Okay, and at some point, even an Attorney Goldberg, got involved and further negotiated with you on the terms of the contract.
Yes.
And did you start coaching Erik full-time even before the contract itself was signed?
I believe I did. Mm-hmm.
And do you recall, excuse me, whether the contract itself, by its terms, began in January of 1990?
By its terms, it began in January, yes.
And do you think for a month, possibly 2 months before that, you were operating under the terms of the contract, even though the contract itself had not been written?
Yes.
And both before the contract was signed and afterwards, how frequently were you being paid?
Once every 2 weeks, I believe.
And you were being paid $5,000 a month, so that would be $2,500 every 2 weeks.
That's correct. At the time, initially, I was being paid $3,000 a month because Lyle was working with us.
So in the beginning, you were coaching both Erik and Lyle.
Yes.
And then at some point, Lyle left the program and Erik remained.
That's correct.
Now, who wrote the checks that paid you?
I'm not sure. It came from a bank back east, I believe, but I'm not sure who signed the checks. It's something I can't remember.
Okay, so you don't know if he signed the checks.
No, I don't know that.
They came from an Eastern bank.
Yes.
Do you even know if it was an account of Erik's or someone else's account?
I'm not quite sure about that. I think it was a trust account, and that's all I can remember.
And you don't know who the trustee was or what
No,
the
I
name
don't.
of the trust? Do you think it might have been, I'll strike that. Were you aware at the time that Erik's Aunt Martha was handling all of his money?
I think I was aware of that, yes.
And she was paying all of his bills, making all of his purchases?
To the best of my recollection.
Okay. And that's, his Aunt Martha is Marta Cano.
Yes,
And you understood that she was Jose Menendez's sister.
yes, I did.
Now, at some point, did you become aware of the fact that Erik moved to an apartment at the Marina City Club?
Yes, I did.
And was the Marina City Club a facility that had tennis courts and a gym?
Yes, it did.
And as part of your regimen, this training for the professional circuit, did it include physical training, such as you'd need a gym and weight machines and that kind of thing?
Comprehensively. Mhm.
Comprehensively?
Yes.
Really hard work, I gather.
Well, I interviewed different weight training coaches, and we found one that we thought would work the best with the boys, and it was pretty pronounced training. They did
Okay.
our-
And did you conduct this training with Erik at the Marina City Club using their facilities?
Yes, I did.
And had you explained to Erik, even before he moved to the Marina City Club, the nature of the training program you had in mind,
Yes, I did.
and that it would include weight training?
It included many things.
And did you suggest to him in looking for a place to live, he should try to find a place that had all the facilities he needed for your training program?
I don't think I suggested that. I think they had decided and suggested it to me.
Okay. And did that sound like an appropriate place for you to do the training that you needed to do?
It did. It was close to where they had lived and their friends, and it seemed to be a pretty complete facility.
Now, you've indicated that during the period before Mr. and Mrs. Menendez were killed, you didn't see Mr. Menendez very frequently at the house?
No, I didn't. He worked in the daytime except when he had meetings there, and I was always there in the daytime.
Okay. But you did see Mrs. Menendez there, did you not?
Yes, I did.
And did she seem sad and lacking in energy to you when you saw her?
She did. Yes, she did.
You said that you saw Erik after his parents died at the Bel Air Hotel, correct?
Yes,
Did you see Dr. Jerome Oziel there?
I did.
And was there anything about his behavior there that you noticed?
Objections beyond the scope and calls for speculation.
Be more specific as to what you're asking. The objection as far as beyond the scope is overruled.
Okay. Did you see the way Dr. Oziel was behaving with respect to Erik and Lyle and the family members?
Objection vaguely ambiguous.
Do you understand the question?
Yes, I do.
Objection overruled.
When I walked into their suite, he
Right,
was.
your answer is yes, you did observe that.
Yes, I did.
Okay.
Did you observe Dr. Oziel behaving in a sort of overbearing and domineering way?
Yes, I did. I could say that.
Do you recall, strike that, concerning your training of Erik, once he moved to the Marina City Club, would you go there early in the morning and get him up and then work with him all day long?
Yes, I would.
Did he tell you during that period of time that he was having bad dreams?
Yes, he did.
Was there a particular day in November of 1989 that he told you it was the first day he didn't cry since the death of his parents?
Yes, I believe he said that to me.
Based on your knowledge of Erik before his parents died, did he ever indicate to you in any way, by anything he said or did, that he had any particular interest in money or material things?
Objection calls for hearsay.
State of mind, Your Honor.
Calls for conclusion on the part of the witness. Objection sustained.
Well, did you ever hear him express any interest in obtaining money? That stage of his life.
No, I can't say that I did.
Mr. Heffernan, you have a PhD, do you not?
Yes,
In
I do.
what?
In clinical psychology?
You're a sports psychologist as well
Yes.
as a coach, are you not?
Yes.
And as a layperson, do you think that you are qualified, based on your interaction with people, to form an opinion as to whether someone appears to be materialistic or not?
Qualified.
Excuse me?
Qualified. Yes, I was as qualified as anybody else.
Exactly. And did Erik Menendez ever strike you as being materialistic?
Objection sustained.
May we approach him? Tired of approaching him.
There's no reason to approach.
Now, after, strike that, during the period of time when you were operating under this contract to coach Erik and for some time Lyle exclusively, did it appear to you as a coach and a sports psychologist that Erik had difficulty concentrating?
Yes, he did have that.
You were with Erik in Israel, were you not?
I was.
And when you were with him in Israel, did he appear to be extremely lonely?
That would be fair to say.
Did you feel that during that period in Israel that Erik seemed to be emotionally disintegrating?
Objection sustained.
Did his emotional state appear to did he seem to get more and more emotionally upset, depressed, sad during that period that you were with him in Israel?
I would say that he would be. He couldn't commit as well. That's how I would phrase it. He couldn't
You have
commit
to speak
to
up a little. Even with the mic, I can barely
Okay.
hear you.
He wouldn't commit to the training quite as much as he had before. He was feeling a range of emotions that would be integrated. I'd say there was many emotions he was feeling.
And that seemed to be interfering with his ability to commit himself to the training.
Yes, it would.
You worked with both Erik and Lyle for some period of time in 1988, 1989, correct?
Correct.
In comparing them, just based on personalities, would you say that Erik was more sensitive, more artistic, and less self-confident than Lyle?
Objection sustained.
After the deaths of their parents, did you ever see any signs of happiness in Erik?
Objection, vague and ambiguous.
Rephrase the question, please.
Did you ever see Erik acting like he was happy-go-lucky, carefree after his parents died?
Same objection.
Overall.
Yes, I did.
When was that?
Different times, not a lot of them, but there were times.
Did you talk to him after he met his girlfriend, Miss Terlesky?
Noel,
Yes, Noelle Terlesky. I'm using the last name for a reason. I'll tell you in a minute.
did I talk to him?
I mean, did you see him after he knew her?
Oh, absolutely.
And did his relationship with her seem to improve his spirits?
Yes,
Sustained.
Well, it's foundational to asking another question. Well, never mind.
Let's get to the next one then.
Was
Objection
that when-
sustained. The answer is stricken if there
Was
wasn't.
that when you saw Erik being more happy after he met that young woman?
that was some of the time. He was happy before he met the young woman as well, on occasion.
Do you recall what those occasions were?
We shared some fond moments in New York.
That was with you?
That was with my wife and I and Erik.
Did Erik have a good relationship with your wife?
I think he did.
Were there occasions, or at least one occasion, when you went to Erik's apartment at the marina to wake him up and found him crying?
He had the door closed for the most part in the mornings, and he would take longer some mornings than others to rouse himself. So he would come out a little deflated in emotion occasionally.
But my question was whether you ever found him crying.
In the morning, no, I can't say that I did.
Did you tell Miss Lansing in an interview with her on July 18th, 1992, that you would go to the apartment at the marina to wake Erik up, and on occasion you found him crying?
I found him crying one particular afternoon when he
Okay.
was reading a letter, I think, from his brother.
He was reading a letter from his brother.
Mhm.
Is that yes?
Yes. Sorry.
Now, you've testified that you believe you gave Erik a tennis lesson on Friday, August 18th, 1989.
I believe that I did.
Okay. Now, ordinarily, did you keep an appointment book that indicated all of your coaching appointments?
Yes, I kept it, in the moment. I saved the appointments for a few months, and if there was no important notes, I discarded them.
And you no longer have that appointment book?
No, I don't.
And have you had anything, any writing of any kind to refresh your recollection as to when you gave that tennis lesson to Erik just before his parents died?
Writing? No, not writing.
Is there something about, well, we strike that and ask this. Did you also coach Lyle that day, or was it just Erik that you gave the lesson to?
I believe it was Erik.
And you believe it was Friday morning?
Yes.
And ordinarily, would you do your coaching in the morning with Erik?
Ordinarily, there wasn't an ordinary time with Erik.
Was that you would just fit in as much time as you
Yes.
could?
Mhm.
If you coached on the weekends, would that tend to be in the morning?
It would be when Erik was available.
Okay. Now, was there something about that last coaching date before the parents died that makes you believe it occurred on Friday,
Yes.
August 18th?
Yes, there
Would
was.
you tell us what that was?
I was seeing what their schedule would be for the weekend, and he said, "Well, we're not going to be taking a lesson tomorrow because we're going fishing with our parents."
So this is Erik said, I can't take a lesson tomorrow. We need
Yes.
to Saturday because we're going fishing with our parents.
And I believe he said he would call me on Sunday to let me know what we were doing for either the rest of the weekend or next week.
Did he call you on Sunday?
No, he did not. Actually, that's not correct. He called me at 10 minutes to 12 at night.
Yes, I know. He called you
Mhm.
after the parents were killed, correct?
Mhm.
And in fact, you went to the police station and were
Yes.
talked to that morning. Have a moment, John.
Yes.
Thank you, Mr. Heffernan. I have nothing further on it.
Any redirect?
Yes, thank you. Mr. Heffernan, when you saw Erik Menendez on the 18th of August, how did he appear to you? Was it just a regular practice session?
Yes.
Nothing remarkable about him on that date?
I can't say that I remember that if there was anything remarkable.
Now, would you say that Erik Menendez, when you were coaching him, was a strong athlete,
Yes, I would.
an aggressive athlete,
Yes.
very driven?
Driven, I'll qualify the very.
Very intense on the court?
Could be very intense.
He's about 6 feet tall,
Yes,
strong,
strong.
and so was Lyle.
Yes, he was.
Both pretty aggressive.
I'm gonna
And the
object
tennis
to
court.
that, Your Honor.
Objection overruled.
I mean, if it's modified by tennis court, I would rather judge.
That's what you're referring
Yes,
to?
Your Honor.
Yes, they were both aggressive athletes.
You had indicated that there were times that you saw Erik Menendez after the killings that he was happy, appeared to be happy. Was one of the times when he met this Noel Terlesky?
Yes, it was.
Were you aware that Erik Menendez bought himself a new Jeep in October of 1989?
Yes, I was.
Did he appear to be happy after that with the Jeep?
That would be fair to say.
Okay. You indicated that there was a condominium that you visited in Marina del Rey at the Marina City Club.
Objection,
that-
Your Honor, testify to.
Let's clarify that.
Okay. What was your understanding of the residence of Erik Menendez at the Marina City Club? What was that?
He and his brother rented 2 apartments,
Side by side?
side by side.
Okay. How many bedrooms did Erik have in his apartment?
I think 3, 2 or 3.
Was it a nice apartment?
Very nice.
Did it have nice furnishings?
Yes, it did.
Did he have a lot of CDs?
Your Honor, I think this is somewhat irrelevant.
Overruled.
I think he did.
Did he appear to be happy with his new apartment?
Yes, he was happy with it.
Okay. Were you aware that he had purchased a pool table for himself in November of 1989?
Yes, I was aware of that.
Was he pretty happy about that?
I think he would be happy about that. Mhm.
Did you notice Erik Menendez's spending? You had spent some time with him before the killings of his parents, correct?
Your Honor, I'm gonna
Correct.
object, this is beyond the scope.
Overruled.
You may answer, Mr. Heffernan.
Correct.
Did his spending change after the killings? The type of spending that he did that you saw?
It changed somewhat. He all of a sudden had access to buy what he wanted, so it
Now-
did change.
This $5,000 per month that Erik Menendez, for Erik Menendez's lessons,
Your Honor, judge actually before
On the next question.
on this line of question, given the court's previous ruling.
All right, you may approach. All right, you may proceed.
Thank you, Your Honor. Mr. Heffernan, you indicated on cross-examination that you saw the parents watching practices, most particularly, I guess, Jose would watch practice.
Occasionally, yes.
Did he appear to be interested in his son?
Yes, he did.
Did you ever see either Mr. or Mrs. Menendez at any tournaments that Erik Menendez was involved in?
Yes, I did.
Did they appear to be supportive?
Yes, they did.
When you were paid, before you were paid $5,000 a month, did you indicate that Mrs. Menendez would pay the $55 fee?
Yes, she did.
She paid you by check?
Yes.
Did you actually see any interaction between Mr. Menendez and Erik Menendez at any matches that you witnessed yourself?
Yes, I did.
What sort of interaction did you see?
I saw different interactions.
Did you see any interaction of support by
I'm
Jose
gonna object to
Menendez?
leaving, Your Honor.
Overruled.
I would think that he was supportive. Yes. Mhm.
Did you see any actions that Jose Menendez took toward his son after any matches?
Yes, I did.
What did you see?
One particular time comes to mind where Erik was playing a very good player in like the third round or quarterfinals of a tournament, and Jose afterwards took him aside as soon as he came out of the gates of the tennis court and was talking to him with his arm around him, but firmly. And I felt at the time that maybe this was I wish he had given Erik some space. That's what my feeling was. But it could be construed as both support and firmness.
As a coach for many years, you indicated having students, 15 to 25 students before you had the exclusive relationship with Erik Menendez. Did you see other parents of good caliber tennis players acting the same way toward their kids? That is, supporting them and being interested in coming to their lessons?
I object to that, it's irrelevant.
Sustained. Objection sustained.
Was in your profession, had you seen other parents that were also interested in their children?
Objection.
Objection sustained.
You indicated that you were with Erik Menendez in Israel. Is that correct?
That's correct.
Was there a time that Erik Menendez received a call that his brother had been arrested in the United States for the murder of his parents?
Objection, hearsay.
You lay a foundation, please.
Yes. Were you with Erik Menendez at any time in Israel where he indicated to you that he had received a call concerning the fact that his brother had been arrested for the murder of their parents?
Your Honor, I'm going to object to this. It is beyond the scope, and I'd like to approach this previous ruling.
All right, you may approach.
Mr. Heffernan, do you know what the letter was about from Lyle Menendez to Erik Menendez?
No, I don't.
Objection calls for hearsay evidence.
All right, the answer is he doesn't. Objection.
Your Honor, I have nothing further at this time.
Okay.
Mr. Heffernan, did Erik seem to have all the disposable money he needed before his parents died?
I think he had adequate disposable money.
Do you recall telling this Lansing on July 18th, 1992, that the boys were used to having all of the disposable income that they needed?
I don't recall that, but I could imagine saying that.
Well, does that seem to be the truth?
I don't think they did without.
Right. And was it your experience with them that they both spent a lot of money before their parents died and they spent money after their parents died?
That'd be fair to say.
And did it seem to you that they, before their parents died, that Erik seemed to have everything that he needed? He didn't want for anything, did he?
I don't think he wanted for anything.
And he didn't complain about needing more of anything, did he?
Overall.
I didn't hear him complain.
And he had a lot, I mean, when it came to tennis, he had all the tennis clothes and tennis equipment and tennis rackets that he could use, didn't he?
Yes, he did.
He had a car of his own.
I believe he did.
You used the term, when you made this observation of Mr. Menendez with his arm around Erik being firm. Is firmness the equivalent of critical?
It could be.
Was it on that occasion?
I think he was trying to have Erik see that he could have played a more creative match.
So he was criticizing his performance, basically, telling him he didn't play the way he thought he should have.
This states the evidence, Your Honor.
Objection sustained.
Was he telling Erik that Erik hadn't played the match the way Jose thought he should have or could have?
I believe that's correct.
Now, concerning this, the things that you observed Erik being happy about, did you ever observe him being happy about the death of his parents?
No, I did not.
Concerning Erik and Lyle, did it appear to you from the very beginning when you started coaching them that they had been professionally trained, professionally coached for a long time before you got there?
I think this has been asked and answered.
Not before the jury, Your Honor.
Okay, then you're correct. Objection overruled. You can
Thank
answer.
I believe it would appear that they had been professionally trained.
And that would lead you to conclude that there had been professional paid coaches in their background before you came along.
Yes.
And you said in response to Mr. Kuriyama's questions that both Erik and Lyle were aggressive athletes. Is that a positive attribute in a tennis player?
It can be.
Did you ever see Erik aggressive in any other way? Did you ever see him physically aggressive with people?
In play only.
Did he ever complain to you about his parents?
Objection sustained.
Did he ever say anything negative to you about his parents?
Objection is hearsay.
No, it goes to state of mind, given the people's theory.
Well, counsel, let's not argue the matter.
Okay.
Can we have a time frame in which you're asking this question?
Well, before they died, which would be 1988. When do you think you started coaching around? Was it around November of 1988?
It was in the early winter, somewhere in there. Yes.
Okay, of 88, and up until the parents died in August. So that would be less than a year.
Yes.
During that year, did Erik ever say anything negative about his parents?
I can't remember if he did. It doesn't come to mind.
Thank you. I have nothing further.
All right, any redirect rather.
Just a couple of questions, John. Mr. Heffernan, were you aware that Erik Menendez received an allowance of $180 a month? That's what his allowance was?
I wasn't aware of that.
Okay. And at the time that you first met him, was he driving a Ford Escort?
Yes, he was.
Okay. So isn't it true that you, in a report dated July 12th, 1993, that you indicated that he seemed to, yes, page 3 of 3 of the report, July 12th, 1993. It's the last sentence. Mr. Heffernan,
I
Did
would
you-
ask rather than hearsay, Your Honor, that Mr. Kuriyama just asked the question.
Objection overruled. Why don't you go ahead?
thank you, Your Honor. Did you indicate that Erik Menendez seemed to spend a lot more money on a much larger scale after the deaths of his parents?
A larger scale, absolutely.
Thank you. No further questions.
Anything else? All right, thank you. You may step down. You're excused.
Thank you.
It's possible that you'll be recalled, but thank you at this point. And did you have any brief stipulations you wanted to recite at this point, or?
I have, well, actually, let me just go ahead.
All right. Okay. As far as the case of People versus Erik Menendez, we're fairly close to the end of the People's case. They have, at this point, it's my understanding, one more witness that they'll be calling, or two, perhaps, two witnesses, and there's some stipulations or agreements that both sides have entered into that will be recited to the jury on Monday morning. And
Just for a second on scheduling.
yes, and then I'll give you a little more information regarding the next phase of the case, the defense phase of the case. I'll talk to the lawyers about their concerns as far as scheduling here. All right, just to get back with you, ladies and gentlemen, we'll resume at 9 o'clock on Monday. We have witnesses lined up, things are ready to go. So as soon as everyone is here, we'll start up with the testimony. And after that, there'll be a break. It's unclear how long. And then the defense case will start. It should be in the morning as well, but things have a way of changing, but hopefully it'll be in the morning. And at this point, let me just remind you of things I've told you about before. Don't discuss this case with anyone. Don't form any final opinions about it. And don't permit yourselves to be exposed to anything about this case in any form whatsoever outside of the courtroom. Make your decision based only on what happens in the courtroom, the evidence in the courtroom, and my instructions on the law. We'll see you all back here Monday at 9 o'clock. Have a good weekend. presented. The jury is not in the courtroom at this moment. Counsel had a matter that you wanted to discuss, subject to, or relating to rather, the proposed testimony of Detective Zoeller.
Yes, Your Honor. Mr. Kuriyama notified us of the pages that he intended to have Detective Zoeller testify to, and what we provided the court this morning was a copy of those pages with notations as to where in Signorelli's testimony that particular language appears. Our objection to what Mr. Kuriyama intends to do is that Mr. Signorelli has already testified to much of these matters, in fact, all of the matters, and that he shouldn't be permitted to prove it twice when it's already in the record.
Mr. Kuriyama?
Your Honor, I had notified the defense that I intended to elicit questions regarding statements that Erik Menendez made on November 29th, 1989 on B13, 14, 16, 19, 20, 21, 22, and 23 of the transcript of that particular conversation. I have agreed that I will only ask questions about the statement that Erik Menendez makes on B22 of 23. This has already been ruled to be admissible by this court on July 26, 1993 at page 7727. The court indicated in a 402 hearing that that statement is admissible. The particular statement that I want to elicit from Detective Zoeller was not asked of Mr. Signorelli. Detective Zoeller heard the statements made directly from Erik Menendez on November 29th, 1989. He was the one who was in charge of recording the conversation, and he is a witness who can testify as to what was stated on that particular date because he listened to it as it was coming directly from Erik Menendez. So I believe that the people should be allowed to elicit this testimony from Detective Zoeller at this point.
Your Honor, what was...
Let me ask that Friday afternoon, the defense gave the court a list of citations to the Signorelli transcript, and I reviewed those, and basically what you provided me today is the same,
Yes.
except that you've given me the actual pages of the transcript and highlighted those things that people intend to offer. And the number of references that you gave me Friday has been reduced considerably now to just one reference on page 22 of the transcript.
Yes, which goes over to the first 4 lines of page 23, B23 of the transcript.
Okay. And what is the defense response, briefly?
Your Honor, our response is that Mr. Signorelli's testimony clearly was that Erik indicated that persons other than he and his brother were responsible for this crime during the course of the November 29th conversation. And Craig Signorelli testified to various remarks by Erik that shifted the blame to other people. What the prosecution seeks to introduce now is just another remark which seeks to shift the blame to other people and just uses a little bit different language than was used before. So this is a theme that has been testified to.
Well, at this point, go ahead.
Moreover, the problem with having Detective Zoeller testify to this is that you lose Erik's demeanor, his tone of voice, and all sorts of things that are important in evaluating this and putting this remark in context. So I think that it is particularly unfair to take this particular theme and isolate it and put it on via the testimony of Detective Zoeller without the jury being able to assess Erik's demeanor, his tone of voice at the time he said it, and his attitudes as expressed in the tape. Right, and Signorelli could testify to that as well because he was sitting there with Erik and he had access to his demeanor in a way that Zoeller, who was sitting in a van or something listening to a tape recording, did not.
Well, let me just respond and resolve this matter It's true that the people could prove this by some other means, including the testimony of Mr. Signorelli, but that is not a bar to the introduction of the evidence. It's certainly an area that the defense can respond to if they choose at some later time by recalling Mr. Signorelli and establishing the demeanor that they feel is necessary for the jury to have a complete understanding of the statement and the defendant's demeanor, or the defendant himself during examination, if he in fact does testify, can certainly be the subject of inquiry in regards to this in great depth. But people have a right to put on this evidence. This is not the testimony of Mr. Signorelli at this point, but the testimony of Detective Zoeller, overhearing statements made by the defendant, and the people have a right to introduce that. It has not been covered in the testimony of Detective Zoeller, and the people have a right to introduce this evidence. So the objection is overruled. It's relevant evidence, probative evidence, and if there's an objection under Section 352 of the Evidence Code, the court finds that the probative value substantially outweighs any prejudicial effect or undue consumption of time.
All right, there's another issue I wanted to bring.
Yes.
And that has to do with the way in which the people intend to introduce the evidence concerning the fact that there was a television program. There was a television program that had the initials BBC. If I understand the offer of proof, or if I understand the court's ruling in conjunction with the offer of proof, the people are going to elicit from Detective Zoeller that that was a movie about a son who killed his father. And the problem with that is that's not what that movie was about. Concerning the aspect of that movie that dealt with the death of Mr. Eslamina, what happened was there was a plot among a number of people to kidnap that man, to get him to sign over his assets, and he died accidentally by suffocation in a trunk. Now, I think it's improper for the jury to be given the notion that that was a similar crime to this one, where, and the son, in fact, in that movie was nowhere near the father at the time of his death.
Was the son prosecuted and convicted of the crime?
He was convicted of kidnapping with great bodily injury. I do not believe he was convicted of murder. But my concern is this: if the people want to put on that this had to do, and moreover, my understanding is there's no direct statements by the son in the movie that he hated the father, had a grudge against the father.
No one is saying that this movie is a carbon copy of this case.
Well, I want to make sure.
People are offering evidence that the movie was about a son who killed the father.
But it
And what
wasn't.
you've related to me is that the father died in a plot that was originated by the son, and that the son obviously killed the father, from what you told me. The
Well-
details of it, the specifics of it, are not being offered by the prosecution. So that's all the prosecution is offering, and it seems to me that they're entitled to do that, and it's an accurate representation of what you told me the movie was about.
Well, Your Honor, all I want to know is if I'm allowed to make it clearer that that was a plot among a number of people, and that the father was kidnapped, and the purpose of the plot was to get him to sign over his assets, and he died by suffocation in a trunk. Now,
No, if you want to go into it, we might as well play the movie, play the video. That's entirely what you were objecting to, going into all the
Exactly.
details of it.
but I'm objecting to their giving an impression that it's about a son who kills a father when the son had no direct hand in the killing of the father, and when the circumstances were so different.
Well, you've objected to reference to the Billionaires Boys Club. You've objected to playing of the movie, and now you want to elicit certain features of the movie that you feel distinguish this case from the movie.
no, what
But
I'm-
however, no one is saying that the movie was the same as the evidence in this case, and
Well-
people are not offering that. And if you want to open the door to the specific facts of that plot, then that whole movie is going to be played for the jury. It's that simple.
Isn't that simple?
It is.
Well, my point, Your Honor, is a 402 point, that because it isn't sufficiently similar, a reference to it is misleading and confusing of issues.
It would be
That's my
if
point.
it would be if the movie was played and the jury had to start drawing distinctions between them. But that is not the situation. You're ignoring the statement attributed to your client by Dr. Oziel as to the genesis of this incident and his description of the movie.
He didn't
Yeah.
describe it.
Well, he certainly did refer to it as an overbearing father who, and the relationship between the father and the sons, and the son, and the nature of the plot of that movie, giving him the idea to kill his father.
But you see, you're leaping ahead to make the assumption that we think is the fundamental erroneous assumption here. And that is that this movie is the one that my client was talking about, because it is nothing like what happened here. It is not similar, and it is not what was being referred to, and that's our problem.
Well, that's your argument, not your evidence at this point. And obviously, if you want to do something in the defense that relates to this, you may do that. If you want to open the door now, then I'm saying that we're going to get into the entire plot scenario and the entire underlying story of the Billionaires Boys Club that Detective Zoeller can relate to the jury. And you are going to get into extraneous matters, and the court would tell you that under Section 352 of the Evidence Code, I wouldn't permit it.
Well, but you're not, look, what Dr. Oziel's conclusion was, because he framed it in terms of a conclusion, was after, I think the words were, after having seen this movie that mirrored what he intended to do with his father. Now, that movie does not mirror what occurred here at all. So if the court is saying that this isn't offered by the people to give the jury the erroneous impression that it's a similar crime, then let Detective Zoeller testify, whether on direct clause, that the facts of that homicide are not similar to the facts of this one, and at least the jury won't be given that false impression.
No, because then you will go into all the details of the movie as to what was shown, whether it was true or not, and whether it was factual or not, and it's entirely extraneous. And
But then he's saying it's a movie about a son who kills a father is a conclusion that isn't borne out by the facts either.
from what you told me, it's a conclusion that's borne out by the facts. There's no dispute from what you told me that the son was killed and it was a result of the father was killed and it was a result of the plot hatched by the son.
No, the son didn't hatch the plot, but whether he did or not, the point is, if you say a father killed by a son, everyone is going to assume it's by the son's hand. That's the clear meaning of the language.
Your Honor, if I might.
Yes.
Mrs. Abramson claimed that she had never seen the Billionaire Boys Club, and I think that still is true. What it is in the movie, a young man states that he hates his father, that his father was once mad at his brother, made his brother put out a cigarette butt in the palm of his own hand, that the father was worth $30 million, and thereafter there's a plan to kill the father. The father is then murdered, and the son tried to blame the killing on political terrorists. Now, with respect to the plan itself, the plan was to kidnap him, make him sign over the $30 million, and then to murder him. In the movie, what happened is they kidnapped the Mr. Eslamenia, they put him in a crate, and before he could sign over the money, he suffocated. So the only things that I would elicit from Detective Zoeller would be the relationship to the father of the son, his statement that he hated his father, the father was worth $30 million, and
No, that again is not what I said would be admissible. I said that was you can refer to it as a movie about the son who killed his father, and that would be the end of it.
And that it was entitled BBC.
Yes. And if the defense intends to pursue this matter, we'll hold a hearing outside the presence of the jury during the defense case, and we'll deal with it. But it's going to be a substantial burden by the defense to justify going beyond what is being offered here. I'm not going to permit it during the cross-examination of this witness. You can recall him during the defense case and conduct further cross-examination if you choose, and we'll hold a hearing outside the presence of the jury where you could lay a foundation by the defense for the issue that you're attempting to present to the court at this time. All right, anything else now before the jury comes out?
no, Your Honor.
All right, then let's get the jury out, please. And the jurors are all in court. Good morning to you, ladies and gentlemen. And we're ready to resume with the trial in the case of People versus Erik Menendez. You may call your next witness.
Thank you, Your Honor. The people call Valerie Hart.
spell your last?
Valerie Hart, H-A-R-T.
All right, if you pull a little closer to that microphone so we can all hear. All right, Mr. Kuriyama.
Thank you, Your Honor. Ms. Hart, directing your attention to October 15th, 1989, how were you employed?
I was an agent working for a developer at the Marina City Towers. The developer.
Would you describe for the jurors what that development entailed or what it was about?
It was a conversion from apartments, 600 units. They're luxury high-rise. They're 1, 2, 3 bedrooms and penthouses.
On the afternoon of October 15th, 1989, did some young men come in to take a look at a penthouse?
Yes,
And do you see one of the young men in the courtroom today?
yes.
Would you identify him for the
It's
judge?
Erik Menendez.
And what is he wearing today?
Your Honor, I will stipulate that she recognizes Erik Menendez.
All right, you join that?
Yes,
Oh,
I'll stipulate it,
okay.
Your Honor. Ms. Hart, was the defendant Erik Menendez in the company of anybody else?
Yes.
Who else?
Lyle Menendez and Noel.
And Noel, would you describe Noel?
Tall, thin, brownish hair,
About how old?
early 20s.
On that day, was there a request made of you by any of those three persons?
Yes.
And who made the request of you?
Lyle.
And what did he say?
He wanted to see the largest unit condominium we had for sale.
And did you then show them the unit?
Yes, I did.
What was the unit?
3,000 square foot penthouse, 2 bedrooms and a den.
Was it the largest penthouse that you had?
Yes, it is.
What was the sale price of that?
$990,000.
Now, what specifically did Lyle Menendez say in the presence of Erik Menendez regarding wanting to see this penthouse?
They just wanted to see the largest unit that was available.
Now, when Lyle Menendez made the statement, what did he specifically say to you?
Asked and answered, Your Honor.
Overruled.
He wanted to know what the largest unit we had was, and I told him it was this penthouse, and they wanted to see it. He wanted to see it.
When you say they wanted to see it,
Objection, Your Honor. The witness must clarify her answer.
Sustained.
what did he specifically say? I want to see it, or we want to see it? What did he say?
I can't recall if he said he or they.
Okay. Do you recall testifying yesterday in a hearing?
Objection, Your Honor. She couldn't have testified yesterday.
Yes, you mean Friday, do
On
you?
Friday?
Yes.
Was it?
And I would object to a reference to that because that question was objected to on Friday.
I don't believe that's correct.
Well, you can refresh your recollection and see if,
Do you recall testifying on Friday in a hearing in this court?
Yes, I do.
And do you recall testifying that Lyle Menendez said that we wanted to see a penthouse?
Yes.
Is that what you recalled then?
Yes.
Does that refresh your recollection as to what was
Yes.
said? Now, at some point, did you then show the brothers and Noel this penthouse?
Yes, I did.
And what did you do?
I took them up to the penthouse and they looked around. I explained a little bit about it. And they were talking amongst themselves. And I needed to go back there to the office. And I told them that they could stay there. And if they had any questions, they could come back down to the office.
Do you know approximately what time it was that they arrived at the Marina City Club?
It was early afternoon.
And do you recall approximately how long they stayed?
Over 2 hours.
At some point, did the other young man leave?
Yes.
Approximately how much time had elapsed when the young man left, leaving the brothers there?
The 3 were together up in the penthouse until they came back down to the office, and then Noah left.
Now, during the course of this, some 2 hours that they were looking at this penthouse, did you ever go up to the penthouse and ask them how they liked the unit?
Yes, I did. I went back up. I didn't ask them how they liked it. They were still there.
Did you have
And
a
I just-
conversation with them?
I said, "Oh, you're still here," and then they were all sitting on the ground, on the floor, and talking amongst themselves. They said that they liked it.
Now, at some point, they came back downstairs.
Yes,
Is that to the office where you were?
yes.
And at some point, did they indicate, or did somebody indicate to you their desire to purchase this penthouse?
Object to the use of the word they.
Why don't you rephrase the question?
Did someone indicate to you that he was interested in purchasing the penthouse?
Yes,
Did he indicate to you who it was that was going to be purchasing the penthouse?
I'm going to object on it as vague for, we don't even know who's talking.
One thing at a time. You may ask the question. Go ahead. Objection overruled.
Thank you. Do you understand the question?
yes.
What did that person say to you?
They said they wanted to buy.
Okay, again, you can't say they if it was just one person.
He said they wanted to buy the penthouse.
And was that when Erik and Lyle Menendez were together in your
Yes.
office? Did he use the word? Did he use a particular word?
Why don't you clarify who the speaker is?
Okay, who was the speaker that said they wanted to buy the penthouse?
Lyle,
And did he use particular words? Did he say they wanted to, or
it was we.
we? Now, at some point, did Lyle Menendez indicate to you that there were some changes to be made to the interior of this $990,000 penthouse?
Yes.
I'm going to object to the form of the question as argument.
Overruled.
Yes.
And what did he indicate?
Wanted the carpet changed, the wallpaper removed, appliances added.
When he made the statement about wanting the interior changes, did he make a statement that you can recall as to who wanted these changes?
I can't recall. I can't recall.
May I approach, Your Honor?
Yes.
Sir, I'm going to show you what's been marked as Exhibit 137. Take a look at this document, please.
Yes,
And do you recognize it?
yes,
Are those forms, new buyer information that are filled out at your office at the Marina City Club?
yes, they are.
And were these forms filled out, or some of the forms at least filled out on October 15th, 1989?
Yes,
And you had indicated that the purchase price of this penthouse was $990,000.
Asked and answered.
Overruled.
yes,
Was there a time on October 15th that there was a discussion about a deposit being made on that particular penthouse?
yes,
And was a deposit made?
yes.
Who made the deposit?
Eric,
How much, was it by check?
yes.
How much money was paid?
$29,700.
May I approach you, Peter?
Yes.
On the fourth page of this document, Exhibit 137, appears to be a copy of a check from Erik Menendez. Is that the check that you received?
Yes, it is.
Did you see Erik Menendez fill out the check himself
Yes,
and sign it?
yes.
At some later time, was that contract later canceled?
Yes, it was.
And did you see Erik Menendez and Lyle Menendez at the facility sometime later?
Yes.
Thank you. No further questions.
Cross-examination.
Thank you. Ms. Hart, had you ever seen the young man Noel before us this date, September 15th?
No.
Did you know who Erica Facade was?
Yes,
And did you know that she was Noel's mother?
yes,
And was Erica Facade and her husband living at the Marina City Towers at the time?
yes,
And was it your understanding that Erica, Noel's mother, had referred the Menendez brothers to you?
Yes,
Now, did the Marina City Club have a full athletic facilities?
yes,
It had a gym, it had swimming, it had tennis courts, did it not?
yes.
The check that Erik wrote, do you have it in front of you?
Yes, I do.
Is it drawn on the United Jersey Bank in Princeton, New Jersey?
Yes,
And was it made out to an escrow company?
yes.
And do you recall how it was that Erik wrote this check? Do you recall a conversation initiated by Lyle that resulted in Erik writing this check?
They talked amongst themselves, and I don't know how they decided. The only thing I do recall is that he wrote the check, and there was just a discussion between them if there was enough money in the account.
Do you recall testifying on Friday to the effect that Lyle turned to Erik and said, do you have a check? Would you write the check?
Yes,
Yes, you do recall that testimony. Is that what you recall happening?
One question at a time. Do you recall that testimony?
no, I don't.
Okay. Well, but do you recall that happening, that Lyle asked Erik, do you have a check?
No, I don't.
Yes. How many pages of documents under the new buyer documents are in front of you?
How many pages?
Yes.
I don't know exactly, maybe 20.
Why don't we go through them together? Okay, may I approach your Honor?
Yes.
The document, the page on the, strike that. The first page says new buyer information, correct?
Yes.
What's the buyer's name?
Joseph Lyle Menendez.
That's the only name for a buyer that appears there, is that correct?
Yes, it is.
Now, you do on occasion sell property to more than one tenant, more than one buyer, like joint buyers.
Yes,
And if you had sold this to two people, both names would appear, correct?
yes,
And this entire packet of documents only contractually bound Joseph Lyle Menendez, isn't that true?
yes,
No matter who wrote the check.
that's correct.
Now, also on this new buyer information sheet appears the words "not reported." What does that mean?
After we would make a sale, we need to report it to the developer at his office.
And this did not happen with this transaction, is that correct?
No, it did not.
This transaction was canceled in a week, was it not?
That's correct.
And in fact, on some date after October 15, Joseph Lyle Menendez and Erik Menendez and a lawyer came back to you and canceled the transaction. Isn't that-
That's correct.
Now, can you explain why the date of sale is October 15th, but the date on the check is September 15th?
He wrote the wrong date?
But it's your testimony that the check was given to you on October 15th.
Yes,
Now let's turn to page 2 of this package of documents. This is a direction to the construction office, correct?
that's correct.
And on this document, the name of the buyer also appears.
Yes, it does.
And it's Joseph Lyle Menendez, is it not?
Yes,
Page 3 is a form having to do with architectural flooring and soundproofing requirements, correct?
yes,
And this is a form that the prospective homeowner has to initial.
yes,
And are the initials JLM?
yes,
The next page, the fourth page is the check we've talked about, correct?
yes,
The fifth page is another form for the purchase called a receipt for public report,
yes,
signed by Joseph Lyle Menendez.
yes.
The next is
It's the second page of the first.
second page of the first, also signed by Joseph Lyle Menendez.
Yes,
The next page
It's a public report about the ground lease.
And that's also signed by Joseph Lau Menendez and names him as the buyer.
Yes.
And the next page is a
It's
cover
a
letter,
fax cover sheet to the lender.
and that neither names the buyer nor does it have a signature.
No.
The next is the actual condominium agreement to purchase subleasehold condominium and escrow instructions, correct?
Correct?
And this is a multi-page document, I take it.
Yes, it is.
And on this page, Joseph Lau Menendez has initialed it.
Yes.
And in fact, this also describes that Joseph Lau Menendez is the purchaser and he is to take title vesting as a single man, correct?
Yes, it does.
The second page, he has also initialed a change in the agreement, some
Yes.
modification, correct? The third page, he has signed, he being Joseph Lau Menendez.
Yes.
Then there appears in this package of documents the business card of attorney Stephen B. Goldberg.
That's correct.
And is it your recollection that Stephen B. Goldberg is the attorney who accompanied Erik and Joseph Lau Menendez when they came and canceled the time?
Objection, Vegas, time.
Overall.
Yes.
The next page is another receipt for public report signed by Joseph Lau Menendez.
Yes, it is.
The next page is a condominium conversion disclosure that has no named buyer nor signature of anybody, correct?
Correct.
But the next page is the continuation of that, and it has Joseph Lau Menendez's signature.
Yes.
The next page is a form, supplemental disclosure notice and acknowledgement that requires no initialing or signature, correct?
Correct.
The next page is a continuation of that, which names Joseph Lau Menendez as buyer, and he signs it.
Yes.
The next page is, I take it, a list of requested changes under the name Joseph Lau Menendez, correct?
Correct.
And it also names at the very bottom a Henry Lanio, who's identified as a cousin of Joseph Lau Menendez.
Yes. It's the same thing.
These are like
Repeats,
duplicates.
yeah.
I'm not going to take you. Now, there is nowhere in this entire package of documents except that deposit check that Erik Menendez's name appears. Is that right?
That's right.
And would it be accurate to say that it was Joseph Lau Menendez who was talking to you and making requests and discussing terms and discussing changes during this entire transaction?
Yes.
And would it also be accurate to say that apart from the young men talking among themselves, Erik was silent?
You understand the
Yes.
question?
Yes.
Okay.
Is that true?
Yes.
In fact, isn't it true that at some point at least you noticed that Erik was very quiet and had his head down?
Yes.
Isn't it also true that he didn't look like he was having a good time?
Objection calls for speculation.
Overall.
No.
That's not
I
true.
mean, no, he didn't.
This wasn't like a party atmosphere.
Objection, that's vague and
Rephrase the question, please.
Okay. Would it be accurate to say that Erik did not look like he was having fun?
No, I didn't.
Now, this transaction was canceled in less than a week,
Yes.
but subsequent to this, are you aware that Erik rented an apartment in the Marina City Club?
I don't know when he rented, but I know that he did rent.
And did you know that Noel, Erik Ficati's son, was his roommate in that apartment?
Yes, I did.
And that was not a penthouse, but an apartment.
Yes.
I have nothing further on.
Any redirect?
Yes, thank you, Your Honor. Ms. Hart, have you seen any paperwork?
Well, I
on the-
should, excuse me, I'm sorry, I do want to reserve one question, but I need the reporter's.
Yes.
Did you review before today any paperwork indicating that Erik Menendez had leased a condominium next to his brother?
Yes,
And reviewing that paperwork, do you recall how much it was that he, per month?
Objection, Your Honor, the court's ruled on this.
Objection sustained.
Did you at any time get information from Erik Menendez why they didn't go through with the purchase of this penthouse?
Objection, Your Honor.
From Erik Menendez?
Objection overruled.
You had indicated on cross-examination that Erik Menendez returned with his brother Lyle Menendez with an attorney and they canceled the purchase of the penthouse, correct?
yes.
Was there something stated on that day as to why they didn't go through with this?
Objection, Your Honor. Now he's calling for hearsay, I assume.
Objection overruled.
Thank you, Your Honor.
Yes.
What was said?
I'm going to object unless we know who's talking.
All right, let's lay a foundation.
Okay. Ms. Hart, you indicated, first of all, that Erik Menendez and Lyle Menendez returned to your office about a week after putting this deposit down on this penthouse, correct?
Objection, asked and answered.
Overruled.
Is that correct?
Yes.
And you had an attorney with them at that time.
Yes.
Now, was a reason stated to you why they did not want to purchase this penthouse at that time? In Erik Menendez's presence,
Yes.
who said it?
Lyle.
And what did he say?
Objection, Your Honor, hearsay.
Overruled.
He was going to be purchasing restaurants in Princeton,
Objection, Your Honor, and move to strike.
Overruled.
Thank you.
and that he was going to be out of town a lot, and they decided to rent instead.
And did he indicate that instead of buying the penthouse, that they would lease two condominiums side by side?
Objection, Your Honor, that is leading, that is hearsay.
Overruled.
Is that correct?
I did not lease to them.
Okay, but did they tell you on that day that that's what they intended to do rather than buying the penthouse?
They intended to rent,
I'm
yes.
going to object to the form of the question because she's only
Objection
testifying.
is sustained. The answer is stricken. Please specify who it was that was speaking.
Who was it that made the statement to you on the date that Erik Menendez went to your office with Lyle Menendez, with the attorney? Who was it that made the statement to you regarding canceling the sale?
Asked and answered.
Overruled.
Lyle,
And what is it specifically that Lyle said why the contract was to be canceled?
Asked and answered.
Sustained. You had one question there that was being asked, Mr. Kuriyama. Now you're going back over the whole thing again. So objection sustained.
When Lyle made this statement, was that in the presence of Erik Menendez?
Asked and answered.
Overruled.
And when he made the statement, did he indicate that they would purchase or they would lease two condominiums instead?
Objection, leading.
Overruled.
they said they were going to lease instead.
Okay. Thank you. Nothing further, Don.
All right. Any recross?
Ms. Hart, you understand the difference between one person talking and two people talking?
Yes,
All right, was it Lyle who did the talking again on this occasion when he said he was going back east and he wouldn't be around much, he didn't want to buy?
yes,
And was it Lyle again who said we've decided to lease instead?
yes.
So Erik never said anything that second time either, did he?
No.
Your Honor, I need to be able to check with the transcript from Friday.
All right. Is it here or not? All right. If it's not, then,
It's on its way.
all right. Well, we'll proceed with something else then. You may step down. Don't leave quite yet. There might be something else they want to ask you about. All right. Call your next witness, please.
Thank you, Your Honor. Prior to calling my next witness, if I could read two stipulations. It's the first two, and then the kettle down. This is with regard to the purchase of a Jeep. Will counsel stipulate that Exhibit 138, previously marked, is a true and correct copy of the business records of Bird's Jeep and Eagle of Los Angeles, regarding the sale of a Jeep to Erik Menendez on October 21st, 1989.
Yes, so stipulate.
And people so stipulate, John. Further, will council stipulate regarding the Calabasas thefts that between July 1st, 1988 and July 10th, 1988, Erik Menendez and a friend were at the home of another friend, John List Jr., whose parents were away on vacation. While searching for keys to a van, Erik and his friend found a piece of paper bearing the combination to the List family safe. After the safe was opened, Erik removed money and jewelry. On July 14th, 1988, Erik Menendez and Lyle Menendez entered the Calabasas residence of Michael Ginsburg without permission. They removed a combination safe and its contents from a closet, a VCR, china, silverware, a Solaflex machine, IBM computer, and jewelry. On September 16th, 1988, Erik Menendez surrendered at the Malibu Sheriff's Station accompanied by his father, Jose Menendez, and a lawyer, and turned over most of the property that had been stolen. Erik Menendez gave a statement admitting his involvement in the two thefts without implicating anyone else. Jose Menendez made full restitution to the Lists and Ginsburgs for the property not returned to them. So stipulated?
Yes, so stipulate.
The people so stipulate, Your Honor.
All right.
With that, the people call Detective Leslie Zoeller.
Could you
Right.
finish with Ms. Hart?
Yes, let's call the previous witness back just for a moment. Please come back up here, Ms. Hart. All right, further cross-examination.
Ms. Hart, you recall I was asking you if you recalled your testimony of last Friday concerning how it came about that Erik wrote a check. And you said you didn't remember the testimony. Is that right?
I just said that they had talked amongst themselves and he wrote the check.
What I'm asking you though is, do you remember what you testified to concerning this issue last Friday when we had this hearing with just the judge? But let me ask you this. Do you think it would refresh your memory if I show you your testimony from last Friday?
I don't remember, but I can.
Why don't you just read?
All right, let me read you this testimony. This was a question by the court. Was there any discussion about why he was writing the check or what was going to happen as a result of his writing the check? Answer. Lyle asked him if he had a check, and he said yes. The only thing I recall is there was some concern as to whether the amount of money was in the account. I have nothing further.
All right. Anything else?
Nothing further.
Okay, thank you. You may step down. You're excused. And Detective Zoeller, and I'll see counsel at the sidebar. All right, you can get on the witness stand, Detective Zoeller. You've previously been sworn in this case, and you're still under oath.
Detective Zoeller, directing your attention to November 29th, 1989. Were you conducting an investigation regarding the murders of Mr. and Mrs. Menendez?
Yes, I was.
And pursuant to that investigation, did you enlist the assistance of Craig Signorelli?
Yes.
Had Craig Signorelli given you information about the killings previously?
Yes, he had.
And on that date, the evening of that date, did you see to it that Craig Signorelli was wired?
Yes, I did.
And did you monitor the conversation between Erik Menendez and Craig Signorelli on that date?
That's correct.
There's been testimony regarding, I believe, 2 tapes or 2 machines being used at that time.
Yes.
Would you describe for the jurors what kind of equipment was used?
We had 2 transmitters. One was in the form of a checkbook with a calculator, and the second one was a body wire, and that's a transmitter that has a microphone. The transmitter was taped to his body. The transmitter then transmits to the receiver, which is where I was, and it's in the form of it receives and goes directly into a tape recorder. So I had 2 tape recorders going at once, and the speakers to the tape recorders were going so we could monitor what was being said.
Detective Zoeller, did you monitor the entirety of that conversation?
Yes, I did.
And did you see to it that audio tapes were made?
Yes.
Okay. With respect, have you seen a transcription of the audio tapes?
Yes, I have.
And drawing your attention to B22 of 33, the second side of the first tape.
I have it.
Do you recall a statement made by Erik Menendez as it begins at the middle of that page?
Yes,
Have you reviewed that particular portion
I have.
through the first 4 lines of B23 of 33?
Yes,
Does that appear to accurately reflect what Erik Menendez stated on November 29th, 1989?
yes, it does.
Would you relate that to the jurors?
What the discussion between Eric and Craig were, specifically Eric speaking that he didn't know who had killed his
I
parents.
object to this, Your Honor. This has already been testified.
You're referring to it, the middle of the page or the bottom of the page?
It starts at the middle of the page, Your Honor, with a statement by Eric. It starts, I'm.
I'm going to object to that, Your Honor.
And I thought the reference was to be towards the bottom of the page
Correct.
in our earlier discussions.
May we approach, Your Honor?
Yes.
Detective Zoeller, drawing your attention to B22 of 33, the last 2 lines and the first 4 lines of B23 of 33. Is this conversation that took place between Erik Menendez and Craig Signorelli?
Yes, it is.
Would you read from that transcript that conversation and identify who's speaking?
Yes. Eric stated, man, we're talking about special hitmen, special shotguns, and knew exactly what they were doing in and out of the house. No one saw anything. No one heard anything. Then Craig stated, doesn't make sense. Eric then said, we're talking serious hitmen.
Okay. Drawing your attention to another area, Detective Zoeller. On November 1992, did you receive custody of an audio tape of Dr. Jerome Oziel's notes of the October 31st, 1989 and November 2nd, 1989 sessions that the doctor had with Erik and Lyle Menendez from the Superior Court clerk?
Yes,
And did you listen to the tape at that time?
I listened to the tape the following day.
Did you give a copy to the district attorney's office?
Yes,
Okay. Did you try to identify the movie that Erik Menendez had said he had seen before the murders of his parents, which had dealt with the son murdering the father?
Objection, Your Honor.
Why don't you rephrase the question?
Did you try to identify the movie that was related in Dr. Oziel's notes from his sessions with the defendants, Erik and Lyle Menendez, on October 31st and November 2nd? Did you try to identify that movie?
I'm going to object again, Your Honor.
All right, refer again to the specific conversation between Erik Menendez and Dr. Oziel that was the subject of Dr. Oziel's testimony here.
Okay. Do you recall Dr. Oziel testifying that Erik Menendez had told him that he had seen a movie on the BBC,
yes,
which reminded him of his relationship with his father?
that's correct.
And that after seeing the movie, he had discussed with his brother Lyle Menendez the killing of their own father?
Yes,
And I believe those references appear in Dr. Oziel's notes at pages 2, 3, and 11. Is that correct?
I'm going to object to that, Your Honor. It's irrelevant where it appears in Dr. Oziel's notes.
Overruled.
That
although I
sounds
don't
right?
know the exact pages. That sounds about right.
Now, after listening to this tape, after you received the tape from the Superior Court clerk in November 30th of 1992, did you take steps to ascertain the identity of that tape?
Your Honor, I'm going to object again and ask for the
As to that question, the objection is overruled. You can answer.
Yes,
Now, did you at some point ascertain that there had been such a movie which had played within weeks of the killings?
I'm going to object to the form of the question, Your Honor.
Overruled.
yes,
Was there such a movie?
yes, there was.
And when did it air?
July 30th and the 31st. It was a 2-part
Of 1989?
of 1989, I'm sorry.
Did you ascertain which network played it?
Yes,
Which network played it?
Channel 4 or NBC.
Did this movie on the BBC involve a son murdering the father?
Yes,
I'm going to object to that, Your Honor, it's beyond the court's instruction.
Objection sustained. The answer is stricken. Why don't you rephrase the question, please?
Did this movie on the BBC involve the son being involved in the killing of his father?
Yes.
Thank you. No, nothing further at this time, Your Honor.
Cross-examination.
Got a motion.
Detective Zoeller, concerning this television program, you tried to see if there was anything that could have been what Dr. Oziel claims was said to him by Erik concerning a movie, correct?
That's correct.
You checked with Scotland Yard in England for a while, did you not?
I did.
And it was only in the past few days that you determined that on July 30th and July 31st, there was a movie bearing the initials BBC in 1989 on NBC, correct?
If you could give me your explanation or understanding of a few days, it was
Well,
within the
a
last.
week or two.
That's correct.
And you figured this out by looking at TV guides, correct?
That's correct.
Do you know, based on your investigation of this case, where Erik Menendez was on July 30th and July 31st of 1989?
No, I do not.
Do you know, based on your investigation, that he was not in Los Angeles on those dates?
I'm not aware of that, no.
Are you aware of an interview with a couple called the DeVitos?
Yes.
Are you aware of the fact that the DeVitos house sat with the Menendezes over the summer of 1989?
Not of the whole summer, but a portion of the summer. That's correct.
And isn't it correct that they were house sitting on July 30th and 31st?
I'm not positive, but that could be.
And do you know where Lyle Menendez was on July 30th and 31st of 1989?
No, I do not.
Now, I take it Dr. Oziel did not tell you that this particular television program you have testified to is the one that Erik told him about.
That's correct.
He doesn't know that that's the program, does he?
Not to my knowledge, no.
And you don't know that that's the program either. You're just drawing an inference. Is that right?
Correct.
Nothing further.
Any redirect?
Your Honor, may we approach?
Yes.
Detective Zoeller, did you see this movie that played on the BBC, that played on NBC?
Yes.
Thank you. Nothing further, Your Honor.
All right, you may step down. All right, Mr. Kuriyama.
Your Honor, no further witnesses. The people of the state of California rest their case in chief against defendant Erik Menendez.
All right, subject to receipt of exhibits, the people's case in regards to the defendant Erik Menendez is resting, and we'll take a break, ladies and gentlemen, give you a chance to stretch your legs, get a cup of coffee if you choose, and if you would return to the court at 10 to 11, and hopefully by then there'll be some matters that we'll be discussing with the lawyers between now and then. Hopefully by then we'll have completed those. Don't discuss this case with anyone. Don't form any final opinions about it, and we'll ask that you return at 10 minutes to 11. Documents relating to the defense motion to strike the special circumstance allegation relating to the allegation of lying in wait. Is there anything additionally that either side wishes to offer?
Just to briefly respond to the prosecution's pleading that was filed that we didn't get a chance to respond to in writing. And the response is this, Your Honor, that the prosecution has missed the point of this motion. in that the response is focused on when they learned that the information that they presented to the grand jury was false or misleading. And the thrust of this motion is whenever they learn that information, the fact remains that the picture that they painted before the grand jury was totally false based on the information that we now have. That is the testimony of the coroner as well as the report of Mr. Linhart. And in addition, there is no showing in the prosecution's response that the coroner's testimony that he revealed here at trial was not discoverable by the prosecution prior to its grand jury presentation. And I think the facts suggest just the opposite, that the coroner's conclusions and opinions were and have remained the same throughout the course of the case. So I don't think it's a fair presentation to state in answer to this motion that, gee, this is information which we just learned about and we can't be faulted for presenting information which we had no indication even existed. I think there was an indication that the information that should have been presented was at the disposal of the prosecution from the beginning. And in any event, the thrust of this motion is that looking at what was presented, the picture that was presented to the grand jurors in support of the line and weight special circumstance allegation is totally false. The prosecution's argument that, well, we may have had other theories as to why the line and weight special is true misses the point also, because that the sole theory they presented to the grand jury was that the Menendez parents were attacked from behind, that the parents were sleeping and in the position that they were depicted in the autopsy photographs. That was the sole basis for the line and weight argument that was made, at least as to my client, Lyle Menendez. And it was the sole basis for the argument against Erik Menendez insofar as it supported the elements of line and weight other than being taken by surprise. And it's our position that given the information which has been disclosed both at the trial and in the reports that are before the court by Mr. Linhart, that the line and weight special should be stricken.
People wish to respond.
Yes, Your Honor. The information given to the grand jury, even in light of Mr. Linhart's report, was not false. There is no requirement legally that the victims be asleep. And it would still be our argument, and is still our argument, that based upon the statements, and I'll argue this during the 1118 motion, but it's still going to be our argument that they were probably asleep at the time that the attack began. Counsel indicates that the impression given during the grand jury argument was false. Referring to page 5 of their motion, it is still our contention, even in light of what has been induced at trial, that the victims were taken unaware, and that is all that is required for that particular portion of the line and weight special circumstance to lie.
All right, anything else?
Well, I have one other thing, is that during the grand jury, as to Erik Menendez, I believe that Dr. Oziel's statement wasn't put before the grand jury regarding the fact that this was a murder committed by surprise.
All right, anything else by either defendant?
No, matter submitted.
All right. The motion basically is one that relates to the manner in which the prosecution presented its case to the grand jury. The defense position is that the prosecution did not present all evidence that was available or should have been available to the prosecution relating to how the shootings occurred, and also that the prosecution, in its argument to the grand jury, in its closing argument to the grand jury, painted a picture of the events that were at variance with the physical evidence that has been established by the prosecution's witnesses in the trial. The prosecution's response was first that it did not have in its possession the evidence that has been now introduced in this trial. At the time the prosecution made its presentation to the grand jury, there is a declaration submitted by the prosecution, unrefuted by the defense, that the prosecution did not have the report prepared by Mr. Linhart, which is attached to the prosecution's response brief. And that brief, or that report rather, is dated July the 15th, 1993, which is a date that preceded by approximately 5 or 6 days the opening statements before the trial jury in this case. The defense argument further is that the prosecution should have, even if it did not, the prosecution should have obtained information, if not from Mr. Linhart, then at least from the deputy medical examiner relating to the shootings and position of the bodies, and information that was produced by the deputy medical examiner in his testimony here before the jury. And the defense position is that since these events have occurred in the proceedings, both before the grand jury and in this trial, the defendants have been deprived of their constitutional and statutory rights that relate to grand jury indictments, and that the grand jury indictment relating to the special circumstance of lying in wait is defective because of these occurrences. First of all, in regards to the defendants, there is a difference in their standing here, in that the grand jury had before it, as does this trial jury, additional evidence than just the testimony of the medical examiner. The grand jury, as does this jury, also has the testimony of Mr. Signorelli and of Dr. Oziel relating to statements attributed primarily to Erik Menendez that were received in both the grand jury proceedings and in this trial, as far as the defendant Erik Menendez only. So the position of the defendants is a little different in regards to the nature of the evidence that was introduced. That aside for the moment, and dealing strictly with the legal argument here and the position of the defendant Lyle Menendez, that the special circumstance allegation is defective because of the procedural errors that are alleged to have occurred, and by the nature of the presentation by the prosecution. The court did a review prior to the hearing under Section 995 of the Penal Code. The court did review the transcript of the grand jury proceedings, and the arguments of the prosecution were identified as such. They were not evidence in the case, but only argument to the grand jury, and the grand jury was instructed as to its role to decide whether to return an indictment based on the evidence presented to it. And the grand jury operated as an independent agency, and clearly regarded itself as such by refusing to indict on the financial gain special circumstance sought by the prosecution. So it's quite clear that although argument was made by the prosecution on various theories and commenting on various aspects of the evidence as had been presented by the prosecution, it's clear that the grand jury regarded itself and did operate as an independent agency and evaluated the evidence independently of whatever might have been said by the prosecution in argument. And looking at the evidence that was presented by the prosecution before the grand jury, it's clear that there was sufficient evidence to support the lying in wait special circumstance. The court so found in ruling on the 995 motion, and the court made its evaluation independent of and without considering the argument of the prosecution, but based solely upon what evidence was introduced and whether there was sufficient evidence to support the lying in wait special circumstance allegation. And the court found that there was. The fact that there has been some variance between what occurred in the testimony of the witness, the deputy medical examiner before the grand jury, and what has occurred here in trial, if there has been any substantial variance, that is the result of the vagaries of a trial, that things do change and opinions do change and information is supplied to witnesses that causes change in testimony, and the give and take of cross-examination and further direct examination does cause some changes in the testimony of witnesses. That does not mean that there has been some misconduct by the prosecution in the production of that evidence before the grand jury. It just means that evidence is subject to expansion and clarification based upon further examination, and that's what we saw during the testimony of the medical examiner. And because there has been some change and variation in his testimony of positioning of bodies at various points, again, does not, in my view, change the underlying evidence that was presented to the grand jury or establish that there was misconduct by the prosecution in not presenting the same degree of detailed examination to the grand jury as was presented here in this trial. I don't find that the prosecution withheld anything from the grand jury or that anything was presented to the grand jury that was believed by the prosecution to be incorrect evidence or untrue evidence, or that has been established to be incorrect or untrue or erroneous in any way. So I don't find that the prosecution did anything incorrectly in presenting the case to the grand jury as far as the evidence that was produced. There was some argument made by the prosecution cited on page 5 of the defense brief, which could be argued is at variance with the evidence that has been presented here as far as where precisely Mr. Menendez was located or situated when the shots were fired. But compared to the testimony of the medical examiner and the report of Mr. Linhart that's attached, it's still quite clear that from the evidence, either way, whether it was from the evidence before the grand jury or the expanded evidence before this trial or the report of Mr. Linhart, that there was substantial evidence presented to the grand jury to support the inference that the killings were accomplished by lying in wait, and that there was nothing improper in the presentation to the grand jury that would cause this court to view that the defendants were deprived of their right to due process or the statutory right to a properly conducted grand jury proceeding. And the court, in regards to this matter, at this point referring to the argument of Lyle Menendez, which is one that relates only to the physical evidence at this point, the court finds that there was no deprivation of the defendant's right to a properly conducted grand jury proceeding, and he was not deprived of his due process rights or his statutory rights in the manner in which the grand jury proceedings were conducted by the prosecution. And further, as far as Erik Menendez, since there was additional evidence presented in regards to statements attributed to him that support the lying in wait special circumstance. His position is even less tenable than that of Lyle Menendez. And as to each defendant, the court denies the motion to strike the special circumstance allegation. I don't find that there was any suppression of that material evidence or that the evidence presented was false that resulted in the grand jury indictment. Therefore, that motion is denied. All right. As far as the next matter, there was reference to a motion under 1118.1 of the Penal Code. Is that something you want to proceed with at this time?
Yes,
Okay. Are you carrying the ball with this one too, Mr. Byrd?
Judges, to my client, I am. And
1 second, please. We're going to let some jurors come in before you get going. All right.
Judge, this motion is a limited motion for judgment of acquittal in that it is only directed to the lying in wait special circumstance allegation, the multiple murder special circumstance allegation, insofar as it is based on a lying in wait theory, the allegation of first degree murder, insofar as that allegation of first degree murder is premised on a lying in wait theory. And in addition, the motion is directed to the conspiracy charge. That excludes the allegation of premeditation and deliberation and the multiple murder charge insofar as it is premised on 2 counts of deliberation and premeditation.
When you say that excludes, you mean you're not arguing that point?
Right.
Okay.
And the argument as to the lying in wait special and the lying in wait theories underlying the multiple murder allegation and also the first degree allegation is really a repeat of the arguments we made to the court in the 995 motion. And the authorities which are discussed in that regard are at pages 113 through 121 of the 995 motion. And essentially, Your Honor, those cases point out that to make a lying in wait charge, there has to be 3 separate requirements: an intentional killing, a concealment of purpose as opposed to a physical concealment, a substantial period of watching and waiting for an opportune time to act, and immediately thereafter, a surprise attack from a position of advantage. And we cited to the court a case, Richards versus Superior Court, where the court found on very similar facts to the facts you have in front of you, at least in regard to Lyle Menendez, that there was not enough evidence even to support probable cause as to a lying in wait theory. And here, of course, the standard is higher. On a motion for judgment of acquittal, it's not enough to show probable cause. It has to go beyond probable cause. And it's our position, Your Honor, that there is not evidence in the record sufficient to take the issue to the jury on the issue of lying in wait, specifically with reference to the elements of substantial period of watching and waiting and a surprise attack from a position of advantage. There is testimony in the record on in regard to Erik Menendez, and specifically his statement to Dr. Oziel, something along the lines of a surprise. But that evidence was admitted only against Erik Menendez. So far as the evidence against Lyle Menendez is concerned, there is nothing in the circumstances before the jury right now to justify any inference about lying in wait. It's simply that the crime scene and the coroner, I think, testified about the possibilities there, and specifically that both people may have been moving at some period of time. He also disavowed any theory that the crime scene showed that the victims were approached from the rear and shot from behind. I think the physical evidence shows just the contrary, and especially in regard to his testimony concerning antemortem and postmortem wounding, that there was a certain period of time where people were moving. The crime scene evidence with respect to Lyle Menendez may support speculation, but there is nothing in the circumstances present before the jury at this point, at least with respect to my client, which would justify a conclusion that there was a period of watching and waiting for an opportune time to act. In fact, the circumstances that the prosecution proved up, namely that there was a prearranged alibi with reference to Lyle Menendez, would suggest that the killings were going to take place regardless of whether the parents were taken by surprise or not, since according to the prosecution's theory, this was all prearranged. And the evidence before the court suggests, giving it the people the benefit of the doubt, that they walked into the room and started shooting. That's with reference to Lyle Menendez. There is no indication of any concealment of purpose. There is no indication of any watching, a substantial period of watching and waiting, and there is no indication of a surprise attack from a position of advantage. With respect to the conspiracy charge, the argument is essentially the same. The evidence with respect to Erik Menendez and Lyle Menendez is different. There is no reference in Dr. Oziel's testimony to an agreement reached by Lyle and Erik to commit the crime of murder. There is merely evidence indicating that they were both involved in certain aspects of what the prosecution alleges to be a conspiracy, but there is no showing of an agreement which was consummated on or about August 20th, 1989, which is the charge in the indictment. We would also argue to the court that the overt acts alleged are at this point not supported by any evidence that's before the jury. Specifically, the three overt acts are that on August 18th, defendants purchased 2 Mossberg shotguns. First of all, it appears, Your Honor, that it's a legal impossibility to have an overt act which happens before the conspiracy is formed. This is a point the court brought up when we were arguing the 995 motion, that the way the prosecution alleged this conspiracy, it's alleged on or about August 20th, 1989. And yet they're charging overt acts on August 18th, 1989, which in our view is a legal impossibility. The overt acts must follow the formation of the conspiracy. They cannot predate it. Also, in addition, the charge that the defendants purchased 2 Mossberg shotguns is unsupported as to Lyle Menendez. There is no indication that he was even there. There is no indication that he was acting in concert and in furtherance of a conspiracy with reference to the purchase of the shotguns. The second overt act is that the defendants acquired shotgun ammunition on or before August 20th, 1989. That's sheer speculation. There is no evidence in the record to suggest when, if ever, shotgun ammunition was acquired, and certainly no evidence in the record to suggest that it was purchased on or after the time that the alleged conspiracy was formed. As to the third overt act, that on August 20th, Lyle Menendez contacted his friend Perry Berman to arrange a meeting later that night to serve as an alibi. To the extent there is evidence in the record as to that incident, there is no evidence in the record that that was done in concert with Erik Menendez, or that whatever Lyle Menendez was doing there was in furtherance of any conspiracy which the prosecution alleges had been formed up to that point.
All right, let me hear from the defendant, Erik Menendez.
Your Honor, we are only joining in the motion with respect to conspiracy.
All right,
We will incorporate Mr. Dunford.
and the response by the prosecution.
Yes, Your Honor. As to the requirements for line and weight, the special circumstance, and we have not made a decision yet whether or not we're even going to ask for instructions on a line and weight theory of murder, but we certainly would be asking for the line and weight special circumstance. I think it's clear this was an intentional killing, and there wasn't a concealment of purpose. As to the watching and waiting requirement, it is clear that the shotguns were purchased 2 days before in a manner intended to secrete the fact that they're purchased. They were purchased using false identification in a town at least 2 hours away from Los Angeles, with a false address and a false birth date. It is clear from the statements of the defendants, which have been admitted into evidence, that the maid was not at the residence on Saturdays and Sundays. Basically, the victims were killed at one of the last possible opportunities before the maid, who was another householder, was going to return. So between the time of the purchase of the shotguns and the commission of the murder, it's in excess of 48 hours, which is a substantial period of watching and waiting. It is clear from statements of the defendants, as well as from a look at the crime scene, that the victims were taken by surprise and that the defendants did have a position of advantage in that. Just looking at the blood at the scene, the blood is confined to a very small area. That is the area in front of and on the sofa. In his statement of September 17th of 1989, Lyle Menendez talks to Detective Zoeller and his partner about the habit and custom of his parents to fall asleep in front of the television. And at page 5 of that, he indicates that his mother had insomnia, but if she was tired, which she might have been because of the motion picture fishing for sharks trip, that she might fall asleep. He also indicates at page 16 that his mother was the one that would wake up pretty easily and not his father. In the words of Lyle Menendez to Sergeant Edmonds on this 21st of August of 1989 at page 13 of the transcript, he says, it doesn't seem like they heard anything because they were on the couch and my dad was some unintelligible. And my brother, my dad is usually pretty, and there's the dispute, deaf or good, to hear something. So when he gets up right away, and so I was really surprised that he was sitting on the couch like that. My mother was on the floor like she was trying to get away or something. I don't know. And she wasn't just slumped back. I think from the statements by Lyle Menendez, it's clear that the victims were in fact taken by surprise. And this is a statement by the killer, who would know better than anyone what the circumstances were at the time that his parents were killed. I think that Mr. Burt overestimates the impact of the coroner's testimony. The headshot to Mr. Menendez is indisputably an entrance wound to the back of his head. I don't see how anyone could construe that as being from anything but behind him. And the fact that they were not asleep at the time they were shot does not mean they were not taken by surprise or from a position of advantage. It is still the people's contention and will be our argument that they were most likely asleep at the beginning of the attack. And as far as his argument on conspiracy, he says there was no agreement, but it's very clear there was a plan. And one can mince words as a lawyer, but the plan was to kill the parents. And one of the most startling and chilling aspects of the plan is the discussion whether or not to keep mom in the plan. It's very clear from this discussion of the plan that there was an agreement by the defendants. The fact that each brother may not have participated in each overt act is not a failure. Conspiracy, an act in furtherance of the conspiracy does not need to be done by all members of the conspiracy. The language of the pleading is on or about the 20th, and that gives leeway in terms of when the crime was committed. It's clear that as the overt act of purchasing the shotguns, I don't think it is a correct argument that this was solely something done by Erik Menendez. The gunshot purchase records indicates his signature, but the license used was one acquired by Lyle Menendez, and there's no evidence that Erik Menendez participated in the acquiring of Donovan Goodrow's driver's license. It is not speculation that ammunition was acquired. It is a fact. The parents were killed with bird and buckshot. The coroner removed it from their bodies. So it's not speculation that ammunition was acquired. It is a fact in this case. They weren't beaten to death with shotguns. They were actually shot with them. And as far as the alibi is concerned, Mr. Burt made the point that the alibi doesn't involve, it was not made in concert with Erik Menendez, but we know that shortly after the discovery of the bodies, and in speaking to Sergeant Edmonds, that Erik Menendez repeated that alibi quite readily to Sergeant Edmonds. May I have a moment, please? And I believe Mr. Kuriyama has some points to make as to, that are particular to Erik Menendez, if the court would like to hear
All right.
his arguments.
Just for clarification, I believe Ms. Abramson said that they were just proceeding on this 1118 with respect to the conspiracy, not the lying in wait.
Exactly.
Then I'll submit it on the basis of.
All right, any brief response by the defense?
Yes, just in reference to the one element of the line and weight special, which I think is most problematic here, which is the substantial period of watching and waiting. Her argument proceeds on the premise that there is evidence that Lyle Menendez participated in the purchase of the shotguns on August 18th, and there is a failure of proof in that regard. And even if there was not a failure of proof, her argument is premised on the assumption that because there was some delay between the purchase of the shotguns and the killing, that therefore there was a substantial period of watchful waiting. And the requirement is watching and waiting. That means something more than simply a period of time that goes by between some act and furtherance of the killing and the killing itself, because otherwise any homicide, any murder becomes a line and wait murder by virtue of the fact that some preparation has to take place. By that argument, any time that someone purchases a gun or obtains a weapon prior to a deliberate, willful, premeditated killing, that automatically turns that killing into a line and wait murder because there's been a period of waiting. The requirement is watching and waiting. And that hasn't been met in this case, despite the prosecution's argument.
All right, in this matter, pursuant to section 1118.1 of the Penal Code, the defense is asking that certain allegations be stricken, and specifically the allegations as far as Lyle Menendez, the allegations relating to the special circumstance of lying in wait, and also an argument for closing the prosecution from proceeding on a theory of first-degree murder on a theory of lying in wait, which is arguable whether that can be reached on 1118.1 motion, since it's just a theory of first-degree murder and it's not an allegation per se, and most likely is not subject to an 1118.1 motion. And also the defense is challenging the conspiracy theory, both defendants. The conspiracy in count 3. We have 2 counts of murder and 1 count of conspiracy. And the defense is arguing regarding the overt acts and whether there has been a proof of an agreement to establish the conspiracy, and also whether there's sufficient evidence regarding the special circumstance of lying in wait. The burden of proof in regards to a motion pursuant to section 1118.1 of the Penal Code is whether there is insufficient evidence to sustain a conviction of such an offense on appeal. This court doesn't make a decision as to whether the prosecution has established its burden of proof beyond a reasonable doubt, but just whether or not if there were to be a conviction on these charges, whether or not there would be sufficient evidence to sustain that conviction on appeal, using the standards that an appellate court would use in evaluating such a conviction. And the court finds that based upon the totality of the evidence presented to the jury in the people's case in chief, there is sufficient evidence to sustain a conviction on appeal of each charge and each allegation, and therefore the motions pursuant to section 1118.1 of the Penal Code are denied. Counsel indicated that there is a motion to deal with some testimony to be offered by the defense. And this was first made known to me this morning when we recessed on Friday. It was indicated that there was just perhaps one limited issue relating to the first witness, and that there might be some additional objections to the defense witness who might be testifying this afternoon. Has that been changed your evaluation of the matter,
Well,
Ms. Bazanish?
Your Honor, I believe that the first two witnesses by the defense will be Marta Cano and Diane Vandermolen, but John Greer's the first?
He's either first or second.
Okay, so it'll be Marta Cano and then John Greer. Marta Cano is an aunt of the
No,
defendant.
just answer my question, whether or not you are making some motion that will take
Yes.
some time here, rather than just dealing with one limited issue.
Yes,
Because,
I think
what-
it will take some time.
What I'm concerned with is that we tell these jurors to come in at certain appointed time, and then when they arrive, counsel have all sorts of motions that they want to litigate before the jury comes into the courtroom. We've had the Erik Menendez jury here for testimony, but the Lyle Menendez jury has arrived and has not been in the courtroom. And the understanding was that they would be here in the morning for testimony. And how long is it to anticipate that these matters that you're bringing to my attention for the first time will take to resolve?
As to Ms. Cano, 10 minutes?
And how long will her testimony be?
Probably an hour to hour and a half.
All right, then, and she is not a witness who is requesting that her testimony not be televised. Is that correct?
That's correct.
All right, then let's deal with her at this point. What is it that there's an objection to?
Your Honor, we have discovery of, I believe, 2 statements from Ms. Cano, and evidently there's going to be testimony in excess of those statements, and that's not my complaint. My complaint is that I believe, or I suspect, that she may be testifying to hearsay statements of the defendants. And I don't know if that's correct, but if it is correct, I wanted to bring to the court's attention the fact that I don't think the question should even be asked, because at this point, hearsay from the defendants is not, it can't be offered by the defense. There's nothing to, there are no prior inconsistent or consistent statements to put in because the defendants haven't testified. And so it would be based upon that I would like maybe an inquiry as to how much or what kind of hearsay of the defendants is going to be offered. And I think that it's not admissible at this point in the trial. And that would be the same objection to Ms. Vandermolen when she testifies later.
And you don't have any idea what these hearsay statements might be? You're just assuming there might be some?
Yes, I believe that, I can't remember where I've heard it, but I believe there might be some information which has been gleaned directly from the defendants in this case, statements
You mean
made.
post-offense statements or?
Yes, I believe so. So perhaps we can just ask the defense. If they say no, then we don't have to talk about it anymore.
Right. Is there an intention by the defendants to offer evidence from Ms. Cano relating to things said to her by either defendant after the offense?
Yes, there is, Your Honor.
And what is that?
The evidence we would be offering, we believe goes to state of mind. The prosecution has introduced evidence with regard to the motivation for this killing being a monetary one. And so we intend to elicit from Ms. Cano statements with regard to what the state of mind was with regard to Lyle and Erik and their family's estate, their belief that they were out of the will, their knowledge that there was a $5 million insurance policy, which the father needed to take a physical exam for and had not done so yet and would be doing soon. The fact that they had absolutely no knowledge of the one insurance policy that did pay off. So
these are all things that she learned or will testify she learned from the defendants after the death of the parents?
That's correct, Your Honor. Ms. Cano is a stockbroker, and she assumed the responsibility after the death of the parents of assimilating information about the estate. And her testimony would be that when she presented this information, certain reactions were exhibited by both of the defendants, and information was given to her in terms of what they believed the state of affairs was with regard to their being out of the will, and their knowledge with regard to the insurance policies, all of which I think are extremely probative with regard to state of mind, which the people have put in issue.
Well, the state of mind, again, although we've had testimony regarding conduct of the defendants after the killings relates to state of mind at the time or knowledge at the time of the killings occurred. How does what the defendants state to some individual afterwards prove what they thought at the time of the killings, other than self-serving statements of a person who is under suspicion of a crime or could be under suspicion of a crime?
The statements that they are making a day or two after the death of their parents with regard to the fact that they believe that there is a new will which excludes them. That's always been their state of mind. With regard to the fact that Ms. Cano was attempting to get the company to pay off on this $5 million policy, despite the fact that he had not had the physical for this one. He had the physical for the key man policy. So she had a theory about why they should pay off on that. And the statements of the defendants that they'd known all along that he had not had the physical and that policy was not in effect.
All right.
And so these are not statements after the arrest. They're immediately following the crime as she is developing this information about what assets exist in the estate and what their claim is to them.
Moreover, Your Honor, the people have introduced evidence through Dr. Ozier concerning my client to the effect that he believed there was a will that disinherited him, that he didn't do it for the money. And I think these statements made a day or two afterwards, upon inquiry of their aunt, are just as probative, if not more so, of what their state of mind was 2 days before.
Well, except that they're being offered by the declarant rather than by the opposition. And the opposition offered them as admissions of one sort or another, rather than the declarant offering it to establish his state of mind and his belief, and for the truth of the matter, that this is what the person believed. And that's the issue that the prosecution is objecting to.
Your Honor, I think with regard to state of mind, we are not offering it for the truth of the matter that they were in fact out of the will, or that the insurance policy was in fact in force or not in force. We're offering it to show their state of mind. Now, the people have put on the computer experts to talk about the erasure of an alleged will, that they have clearly put in issue the concept of whether these two defendants believed at the time that their parents died that they were in a position to inherit or not. And if the court goes in the direction that it seems to be leaning at this point in time, the only evidence they could ever produce would be their own uncorroborated statement of what their state of belief was. And if in fact they've made these statements to a number of other people in terms of what they believe the situation to be, and they made them close in time to the death of their parents, it seems to me it's extremely probative, it's corroborative, and it's not offered for the truth of the matter, but merely that it was said, because their state of mind is the key here. The people are going to argue that the reason they killed their parents, or at least one of the reasons, is to get the money, and it becomes extremely important if they think that they're not going to get any money.
Well, but you're offering this to show that that's what they thought. And
that's correct.
My response is that, assuming the people's theory is correct, that the murder was committed to obtain money, the defense response is that a defendant who is so accused would be entitled to offer hearsay evidence of statements made to other people after the incident to prove his motivation at the time the crime occurred. And that's not normally the situation where a defendant or a party is entitled to offer such evidence. It's offered by the opponent as an admission or for some other theory, but doesn't necessarily make the evidence that you're proposing admissible. We'd end up with a situation where an individual accused of a crime such as this would be entitled to introduce evidence that he made statements to others after the crime, self-serving statements, to support the defense.
1250, which is the statement of declarant's then existing mental or physical state, does not suggest any of the limitations that the court's proposing. It says, evidence of a statement of the declarant's then existing state of mind, emotion, or physical sensation is not made inadmissible by the hearsay rule when, 1, the evidence is offered to prove the declarant's state of mind, emotional, or physical sensation at the time or at any other time when it is itself an issue in the action. I think that very clearly covers our situation here. It also says the evidence is offered to prove or explain the acts or conduct of the declarant. So it's our position that there's nothing there that limits who may offer, as there are obviously, as the court knows, in other sections of the evidence code in terms of it can't be something that's offered by the defendant. I think here it makes a blanket rule.
All right, it's an interesting issue and one that should be reviewed, researched prior to the offer of the evidence.
Excuse
And
me,
the court is not foreclosing it. I would encourage counsel to research the subject and present the court with any authorities on that subject. Yes.
I was going to point out that there is a distinction, I think, between what the court is focusing on and I think what this evidence is. I would agree with the court if the defendants had said after the incident, even before they're arrested, we killed our parents, but we didn't do it for the money. Now, that would be a very different situation than what I believe the testimony of this witness would be, which has nothing to do with why they did or didn't do something, but has to do with their understanding, their state of mind vis-a-vis their financial relationship to their parents. So that what I believe this witness will say is that when she confronted them with the fact that there was a contract of services for Mr. Menendez that provided a $5 million life.
Let me interrupt you for a minute. We end up going through these hearings where we have a lot of argument, and then we'll have some more research on the subject, and then we'll probably have a hearing outside the presence of the jury where the witness will testify, and we consume a great deal of time on it. So before we get further along, I assume the defense knows what the testimony will be, that there's no mystery as far as the defense is concerned. You can research the subject. You've already given me an indication of it. Rather than just citing me to evidence code sections, I'm sure there probably are some cases that deal with this subject as well, and we'll review those prior to the testimony being presented to the jury. Does this witness have other evidence to offer besides this?
She does, Your Honor.
And evidence that is not subject to objection? Is that right?
Not that I know of at this time.
All right.
Well, I'm going to be making objections as we go along, but I'm not asking for a 4 or 2.
Okay. All right, let's proceed then. And before we get to this particular piece of evidence, we'll deal with that after counsel have a chance to research the subject. It's certainly something that the prosecution should have been able to research before now. And I'll expect some more incisive argument prior to the completion of this witness's testimony. All right, if there's nothing else, we'll then proceed with the testimony of this witness before both juries. Requested that they not be televised. Counsel for the board concerned with that issue will have to come back later today or at some other appropriate time prior to that witness's testimony. But I want to get some testimony before the jury this morning.
Could you just tell me what the time would be appropriate?
If you might want to consult with the attorneys here, just briefly get some input from them as far as when they expect that first witness to testify.
I mean, I looked at the cases last night and there was nothing.
The information I had was that the witness was testifying this afternoon, but if they'd have a change of schedule, then we can arrange something and allocate some time for it rather than try to deal with other issues.
So then it won't be till tomorrow, so that's something like tomorrow. Right. The first witness that's covered by the court's previous order won't be testifying until tomorrow.
What time? Any idea?
Whatever time we finish with the witnesses today.
I don't know how long the witnesses today are.
All right, you might check this afternoon, it'll be tentatively tomorrow morning, and are you available all day tomorrow, or?
Yes, sir.
Okay, then what we'll do is give you a call later this afternoon, or you can call in later this afternoon, and we'll have a better idea.
What number do I call?
Courtroom here. And then we'll do it before the first witness testifies. All right, we'll be in recess until we get both juries in. All right, both juries are in the courtroom as well as both defendants and all counsel, and we're ready to proceed with the trial. At this point, the defense is going to be calling its first witness. Ms. Lansing?
Yes, Your Honor. Here's called Marta, Cano.
Please remind the case before you swear that the testimony you may give in the cause now only before this question, the truth, the whole truth, and nothing but the truth, so help you God. Would you tell us your full name and spelling out, please?
Yes, my name is Marta, Marta Menendez, Cano, Cano.
All right, they'll arrange that for you.
Thank you, I got it. Yeah, if you could put it back a little bit, I'd appreciate it. Thank you.
All right.
Thank you. Ms. Cano, are you the aunt of Lyle and Erik Menendez?
Yes, I am.
And directing your attention to the family tree, could you identify where you are on that?
Yes, I am the daughter of Maria and Pepe Menendez. I am the second one, the sandwich, the middle one. Jose was the youngest.
Okay. And it says Peter. Is Peter your ex-husband?
Yes, it is.
And listed beneath you are Marta, Eileen, Marianne, Peter, and Andy. Is that correct?
That is correct. Those are my children.
Ms. Cano, where were you born?
I was born in Cuba.
And your brother was Jose Menendez. Is that correct?
That is correct.
And you have a sister named Terry.
Yes,
Is
I
that
do.
correct?
Yes, I do.
And did you live in Cuba in the early years of your life?
Yes, I did.
And at some point, did part of the family move from Cuba into the United States?
That is correct.
Who was the first to move?
To move permanently, you mean?
No, just to leave Cuba for a period of time.
The first one to leave Cuba for a period of time was probably myself and my sister Terry.
How old were you when you left Cuba?
I was 13 years old.
13?
That's correct.
And how old was your brother, Jose, at that time?
Jose was close to 3 years younger than me, so he was about 10 years old.
And did you have an opportunity to observe him growing up to the time that you moved when you were 13 and he was 10?
Yes, I did.
And were there any other children other than the two siblings that you've described? You haven't had any who've since died or anything like that, is that correct?
No, that's correct.
And in your family home, was there a difference between the way you and Terry were treated and the way your brother was treated?
Objection, Your Honor.
Sustained.
May we approach, Your Honor?
No.
Your Honor, I'd like to make an offer because this is going to come up a number of times.
Okay.
Thank you.
All right, let's proceed, please.
Your Honor, I would ask the court's indulgence at this point in time. It's 10 of 12. We have a witness who will be available at 1:30 who can lay the foundation for the questions that I'm asking Ms. Cano. And
that witness is who?
Dr. John Briere.
All right, and is there some issue relating to that witness's testimony by the prosecution?
Briefly.
All right. All right, do you have any other matters with this witness to go on, any other subject, or is that all she was going to testify about?
No, there are other matters, but
I would ask that you go ahead with them then.
did you observe Kitty and Jose Menendez and their children as those children were growing up?
Yes, I did.
And were you frequently in their home?
Frequently enough.
And did you make any observations with regard to the treatment of Jose Menendez of his two boys?
Yes, I
Lack of foundation.
I believe she said she was in
All
the
right, can
home.
we have a foundation as far as time you're talking about, any particular time frame?
Did you see these boys when they were small children?
Yes, I did.
And did you see them regularly during the years they were growing up?
Objection vague.
Well, that's foundational, and you can answer the question. Do you understand what she means?
Yes. Yes, I did.
And were there periods when you were in the house visiting or watching them at various functions more often than others?
Yes.
Okay. And what period of time were you around the family most often?
We were usually together at least 2 weeks during the summer and at least 2 weeks during Christmas holidays, to say the least.
Okay. And did you live near them for a period of your life?
I lived very near them between 1979 and 1986 that I moved to Florida and Jose moved to California.
And did you see the family regularly during that period as well, 1979 to 1986?
Yes, I did.
And were you able to make observations of the relationship of Jose Menendez with his two sons?
Yes, I did.
And did you make similar observations with regard to Kitty Menendez and her two sons?
Yes.
Could you tell me now what observations you made with regard to Jose Menendez and his eldest son, Lyle?
Objection irrelevant, calls for improper opinion.
Well, it's vague when you say observations. Could be more specific as what you're referring to.
Did you observe Jose and Lyle together?
Yes, I did.
And when you observed them together, could you describe what the relationship was? Was it lighthearted and laughing? Was it serious? What was the nature of the relationship?
Objection, vague and improper opinion. And irrelevant.
It's not an opinion, it's her observations.
All right, without the argument, the objection is overruled. You can answer the question.
I observed Jose and Lyle in many ways. Jose was very possessive. It was always a monologue.
What do you mean it was always a monologue?
Lyle was not allowed to express his opinions. He was told what to do. He was directed exactly to Jose's wishes. It was, the boy seemed to be very tense, very frightened, very obstructed to his own opinion.
You're going to move to strike it, calling for a conclusion on the side of witness.
All right, the objection is sustained. The entire answer is stricken since it's gone beyond the question, so you'll have to proceed again.
When you observed Lyle and Jose together, did you observe them having conversation?
Objection, vague.
Ever. The question is ever.
Yes,
Okay.
during the time she was in their presence.
No, there was no conversation. There was a monologue.
And can you describe for us what you mean by there was a monologue?
Whenever a situation
Back up from the,
Whenever a situation occurred that something had to do with Lyle, Jose would tell him exactly what he should do, not do, what he did wrong, what exactly needed to be done in a very demanding, intimidating way.
did Jose attempt to have control over Lyle with regard to the schools to which he was sent?
Definitely,
Objection calls for conclusion.
definitely.
Objection sustained. The answer is stricken.
Did you observe Jose and Lyle in situations in which Jose was having the monologue you described?
Yes, I did.
Can you tell me how young Lyle was when these monologues began?
Oh, always. I mean, he was 2 years old. He would pull him on an arm and say, you stop that and you do this and you stay here and you do that. And
What was different about that from the way you disciplined your children?
I didn't do that to my children.
Objection irrelevant, move to strike the answer.
Objection sustained. The answer is stricken.
Were there periods of time in which Jose would sit Lyle down and give him instructions?
Yes, Jose always gave his instructions separately, though. He would take the boys, especially any one of them, but in this case, Lyle, away from the family. And he would say, come here, I have to talk to you, and go on a place where they could be private.
And how long would these talks last?
It could be from 10 minutes to half an hour.
Objection sustained.
Excuse me, one at a time, I didn't get the objection.
Assumes fact not in evidence, calls for yourself.
Objection sustained. The answer is stricken. If you can back up from the microphone just a bit.
Yes.
Your Honor,
Can you hear me here?
she indicated that he would take him aside and have talks with him.
Yes, I heard
That was the
testimony.
evidence.
Okay, objection
And then the
sustained.
question was, how long would these talks last?
Yeah, the court sustained the objection and stricken the answer. You may ask your next question.
As to the length of the conversations?
Ask another question. You can re-ask it, go on to something else, or ask it another way.
They come back. The game is you don't know if they're talking or not.
All right. Would you see Jose remove Lyle from the company of other people?
Yes.
And would he indicate what the purpose for removing him was?
No, he would just say, I need to talk to you.
And would they disappear from view for a while?
Yes,
And then would they reappear?
that's correct.
And how long would these periods of time be in which they were gone from your view? depending on the circumstances.
Objection overruled. The answer will stand.
What is the range? The range would be between 10 minutes to 35, 40 minutes.
And did these talks occur when Lyle was young or when he was older?
Objection if in fact not evidence.
Objection overruled.
In different occasions at all ages, I recall from
You've
age
answered-
4.
You've answered the question.
Okay. What is the youngest that you remember these types of separate pulling aside to have conversations with and incidents occurring?
4 years old.
And when they would return, how would Lyle look?
He would be very quiet. He would just stay on a corner and practically don't continue whatever he was doing or whatever conversation he was having.
And did you see gestures of warmth from Jose to Lyle?
Not really.
Now, was there a different relationship between Jose and his younger son, Erik?
Yes, there was.
And what was the difference?
Objection calls for conclusion on the part of the witness.
Sustained.
Did you see Erik treated differently than Lyle was treated by Jose?
Yeah.
Objection.
Overruled.
Yes, he was.
And what was the different behavior that you observed?
He was more inclined to be tender with Erik in certain circumstances. He did not see Erik the same way he saw Lyle. Lyle was for his own image. Erik was.
What do you mean by Lyle was for?
A motion to strike the answer.
Objection sustained. The answer is stricken.
What was the behavior you saw with regard to Lyle from Jose with regard to his expectations, if you know?
Can I say what Jose said to me?
Objection hearsay.
Okay.
You can say what you saw. It wouldn't be, Your Honor, I'd like to stay with that other question. It's not hearsay, it's not being offered for the truth of the matter, it's being offered to explain his conduct at the time.
All right, we'll take a recess at this point, ladies and gentlemen, and we'll resume. Since the lawyers have some matters they feel that they want to discuss with me, we'll resume at 2:00. Don't discuss this case with anyone, don't form any final opinions about it, and we'll resume at 2:00. The jurors have left. Did you wish to ask this witness a question in relationship to your last inquiry? You were asking something about a statement attributed to Mr. Menendez.
Oh, yeah, I thought we were gonna, yeah, I thought that when the jury was going to want to do the financial stuff. I'll ask her that. What was the statement that you were gonna testify to with regard to what Jose Menendez said to Lyle Menendez? I said to her, I'm sorry.
To me, you mean?
Yes.
Jose, in several occasions, not only one, he told me that Erik was not like Lyle, that Erik was too soft and too tender, that Lyle was going to be his own image, that he knew that he could work with Lyle and Lyle could be as successful and as powerful as he was.
Your Honor, it is our position that that theme runs through their childhood in terms of the demands that are made on Lyle, the unreasonable demands, the need to make him a duplicate of Jose himself, of taking over Lyle's life, and that with regard to Erik, that he suffered from just the reverse of that, which was being ignored, being rejected. He was a throwaway son, and that there were certain things that happened to him as a result of this underlying perception of Jose, of his two children. And it also affects the relationship of the mother to the two children and what she does in response to the all-consuming interest of Jose with regard to Lyle and his neglect and humiliation of Erik.
And what is the people's response?
Your Honor, people's response that the statement is being offered, I believe, to show Mr. Menendez's state of mind. And at the time that the statement is made, it's unclear when this occurred and what portion of the lives it occurred. It is not a statement of intent on the part of Mr. Menendez, but rather, I guess, just a statement of his state of mind. And we would argue that at this time that is irrelevant to the issues in dispute in this trial.
Your Honor, it's our position that this is not offered for the truth of the matter asserted. That is, that he could really do these things, but that was his motivation and explains his conduct, which carries over until the night that he dies.
And Your Honor will be offering specific examples of how he informed his conduct to these perceptions of each of his sons and his intentions with respect to each of his sons in a constant, repeated pattern over their entire lives, up until the day they die.
Did the people wish to respond to that?
One other thing, I think that all of this evidence that they're going to seek to admit during the defense portion of the case is governed by 1103 of the Evidence Code. And as such, what they're trying to prove is conduct or character of the victim in conformity with something that's going to be at issue in this case. And so it's going to be our continuous objection that when matters are too remote or too unreliable, that they should not be admitted under 1103 to prove Mr. Menendez's or Mrs. Menendez's character.
All right, let me say this, that the prosecution, you can step down, by the way.
Thank you.
The prosecution has received discovery as far as most of the defense evidence, except for statements attributed to the defendants or their proposed testimony. The bulk of, I assume anyway, from the order of the court regarding discovery, that the bulk of the evidence being offered by the defense is evidence that is known to the prosecution. And this is an area that was touched upon in opening statements to some extent by the defense, each defendant, relating to not just the events at or near the time of the shooting of the victims, but also this life history that is now being presented. And my observation to the prosecution is that if you have formulated objections to this, it would seem to me that the prosecution could have filed a substantial trial brief on this subject, encompassing your evaluation of what the evidence the defense is expected to introduce and articulate your objections to it. You have a better feel for it than I do. I'm sure your feel for the evidence is not as good as the defense, but I'm sure it's better than mine, because I really don't know much more than the opening statements and occasional declarations that have been submitted by the defense in support of one motion or another. But this is a substantial issue in this case as far as the nature of the evidence that will be offered by the defense, how much of it is relevant evidence and how much is admissible evidence. There is clearly an issue of remoteness here, that the offer of evidence is that anything that has happened within the entire life of the defendants would be admissible evidence if it relates to the parents. And there is an issue of remoteness as to whether it is relevant evidence. It might be relevant and probative on issues of penalty or punishment, or it might be relevant and probative on issues relating to the charges here before the court that the jury must resolve. It's difficult for the court to evaluate this without knowing the totality of the evidence that's being offered. And my concern is that this is a matter that should have been briefed by the prosecution if you intend to object to great portions of the evidence, and that the matter could have been scheduled for a hearing that could have resulted in evaluation of this evidence in its proposed form, so that the court would be in a better position to evaluate it. At this stage, what I envision is that as each witness is called to testify, the prosecution will state certain objections without an overview of the expected bulk of the evidence that the defense is offering here. And it's very difficult for the court to deal with it in that fashion.
May I have the word, Your Honor?
Yes.
It is not our contention that all acts or conduct in the past is irrelevant. That is not our position. First of all, let me back up by saying this.
Counsel, just be quiet so that the prosecution can respond to my remarks.
Your Honor, we have discovery from many of the witnesses, but as to many of the witnesses, we don't have complete discovery because of the peculiar nature of this case. And we don't know when we don't have complete discovery.
But
Now,
you do know what you do have.
we know what we have, but we don't know if what we have is everything as to that witness. For instance, Ms. Cano has given other statements to the defense. I found that out last week, which we don't have. And I assumed that that might be the case, but I don't know that if we have discovery from a witness, it's the total discovery, number one. Number two,
Well, if it's not the total discovery, then you have an objection regarding the testimony of that witness, I assume.
no,
I
no.
think she's referring to material during the protected period, that we did not
Oh.
need to give up information
All right.
prior to November 6,
No.
1991.
And we're not, there are many witnesses who, about whom we know what they're going to testify to, and we're not going to be objecting. We're not going to have a 402 in front of every witness that testifies. But as to the manner in which this testimony is being elicited from Ms. Cano, I think that it's calling for improper, a lot of it's conclusionary, it's opinion evidence. There's no idea of when this occurred in time. It's all very general. And so as to the way that, I believe that the defense is going to be entitled to put on certain kinds of evidence to support their theory regarding some sort of psychological syndrome or some sort of psychological testimony in this case. But it's more to the form or the way in which Ms. Cano is testifying and the questions being asked, which we could not know in advance, that at this time we're objecting to. Now, I do believe that I filed a motion with the court dealing with objections to the defense opening statement, if the court will recall.
I do recall that.
And in that, I did point out certain of the same things that we're pointing at now and that we will be pointing out later. But specifically in regards to her testimony, it appears a lot of it is conclusionary. It calls for hearsay, and it should not be admitted whether or not the court has advance notice because we didn't know the form of the questions that were going to be asked. So we're not going to object. There are several witnesses who are going to be called that are going to deal with childhood experiences of the defendants in terms of school or coaching or things like that. At this point, we're certainly not going to object to every single one of them. But in terms of this particular witness's testimony, the way that the questions are being asked and the way they're being answered, they are objectionable.
Your Honor, let me say something first, okay? Your Honor, in the very beginning, there was an issue with regard to the applicability of 1107, which is the battered woman syndrome issue. And the people conceded in the very beginning that it was applicable to children as well because of.
They conceded that prior to the defense opening statements and
That's
the
correct.
brief that was referred to by Mrs. Bozanich. The
And-
people did concede that.
Yes, and 1107 specifically indicates that expert testimony can be elicited to show the effect of physical, emotional, or mental acts on the person. Now, in order to testify to the effects of those acts, we need to have the testimony as to what those acts were on which the expert can base their opinion. So it is our position that by conceding that 1107 was applicable in this case, people have waived any objections in this area. For a battered woman, I would assume that if she was married 25 years and was beaten for 25 years, that would all be relevant to her state of mind at the end when she acts out. It is our position that the two young men here for 18 and 21 years were subjected to routine, regular, repeated abuse of a physical, psychological, and sexual nature, and that we have the right to elicit those acts so the jury can know that an expert's not getting up there and saying, well, if they were told this, if they were exposed to that, then it would have this effect on them. We need to be able to establish for this jury that they were, in fact, subjected, in Lyle Menendez's case, to routine, extremely intense programming systems, what the experts will refer to as brainwashing, that they were intimidated, that they were humiliated. All of those are extremely important acts with regard to the condition they found themselves in on the night of the act in question.
All right, what is the people's response to that?
The people's response is that we indicated that analogously to 1107, that we would not object to expert testimony. That's what 1107 covers. It doesn't cover these other things. Now, as to specific acts under 1103, those specific acts in many instances would be admissible in this trial. However, the kind of testimony being elicited from this witness is not dealing with specific acts. The questions call for hearsay, the questions call for opinion, the questions call for speculation.
Well, in regards to the question that was asked of Mrs. Cano and her answer, it does elicit out-of-court statements of Mr. Menendez, and the issue is not what he said, according to the people's position, but what he did, and what he did to the individual defendants. So if,
Your Honor,
yes,
if I may, we are relying on psychological abuse to a large extent, and that is almost always verbal. And so if someone calls you stupid, dummy, if when you wet your bed, your sheets are placed on the table and you're told you're a sissy, all of those are verbal acts. Now, we're certainly not offering them to prove that our clients were dumb or stupid or sissies, but in fact that they were subjected to this kind of treatment. And with regard to Mrs. Bozanich's position now, that they don't object to the experts testifying to their conclusions, obviously, I think we have a right to prove the underlying acts for the jury to evaluate. But in addition to that, she filed a motion some time ago indicating that she was going to object to the experts relying on any hearsay, which means we couldn't even say to them, assuming that parents did A, B, C, and D.
no, I think her objection had to do with statements of the defendants.
No, it was not limited that. It was not limited to that.
Okay.
But I think that our more appropriate position is the fact that if they're going to render conclusions based on acts, we've got a right to prove that those acts actually occurred, and the people have a right to challenge whether those acts occurred.
All right. Well, again, that goes beyond the people's objection to the specific question and answer attempted to be elicited from the witness, that the statements of Jose Menendez were, as she described, and does not relate to what he did, but relates to what he said. And these apparently were statements that are attributed to him maybe 15 years ago or something of that nature. And is it relevant, and is it his state of mind at that point relevant, or is it what he actually did that is within the perception of the witness that is relevant?
It is both, Your Honor, and I think that perhaps when Dr. Briere testifies here this afternoon, he can address the issue with regard to remoteness, that everything that happened in these children's lives as they were growing up, in these defendants' lives as they were children growing up, had an impact on how they perceived their parents and how they perceived their world. And the ultimate issue is going to be whether these were parents that, whom they could reasonably and in good faith believe would kill them. That's what the jury has to end up with under our theory, either that it was a heat of passion type of situation because of the lifetime of abuse and provocation, or that these were parents who had shown in many ways to many people that they were capable of killing their children. So that's why these acts become extremely relevant.
There's one other thing with respect to a statement, basically, a parent's statement that their theories of child rearing or their intentions with respect to a child. What we would intend to do is put those statements on as the parent's state of mind, and then prove specific acts in conformity over the years with that expressed attitude. Moreover, we will be able to put on evidence, Your Honor, that these statements of intent and attitude by Mr. and Mrs. Menendez towards the children were also said in front of the children. So the children understood what the pressures were on them, what their expectations were, what the parents thought of them. And with respect to the notion of psychological abuse, that's directly relevant.
Well, bearing in mind that the people have conceded that evidence of specific acts are admissible, the issue really is whether or not these statements were made before or in front of the defendants that caused them to believe certain things rather than what a parent might have said to someone else, which again, doesn't prove anything actually happened, and the state of mind of the parent is not at issue. It's the actual behavior, apparently, that was perceived by the defendants as at issue. So the objection is sustained as to that question as hearsay at this point without a proper foundation that it was a statement made in the presence of the defendants. And as far as the expert witness, he is here at 1:30. There was some objection to his testimony, and also the defense wanted to make some offer proof with his testimony to perhaps lay a better foundation for the court to evaluate the theory the defense is proceeding under as far as the introduction of this evidence. Bear in mind, this is not something that has been presented to the court before in any format. In this case, this is something that was presented in opening statements, but that's basically it.
Well, I
The court
assume
hasn't
since the
been
people,
presented anything as far as what these witnesses would say.
we were operating on the assumption since the prosecution had our discovery and heard our opening statements that if they had objections, we would have known about it by now. And
Well, that was the intent of my remarks before, that I would have expected that if there was some strong position by the prosecution in opposition to something, that it would have been subject of some motion informing the court of their position and the legal authorities. It's obviously a substantial part of this case and would be something that we would all benefit from presentation from either side. All right, we'll be in recess until 1:30. Back on the record, the defendants are both in court with their lawyers. The people are represented. The jury is not present. The court will proceed with a hearing relating to admissibility of certain evidence being offered by the defense. And I see the prosecution has given the court a copy of its in limine motion filed on August the 16th relating to the opening statement of the defense. And underneath,
I'm sorry, I changed it though. I changed it a little bit.
you changed it when?
During lunch in other words, what I've done, and I think there's reference on the first page, is that most of that is are the points and authorities that were filed originally on July the 13th. I've added a section before the conclusion dealing with state of mind, which is the case that's been given to the court. And there's only really 2 or 3 pages of that case that are applicable, the Edwards case. But I changed some of the wording in the motion as well, so it's not identical.
All right, so this is a different motion. What pages are there that you wanted me to look at so I don't have to read the whole thing again?
Your Honor, it would be right before the conclusion. Let me, where's our copy of the motion?
Page 26, we're talking about just that one page?
Well, yes, as to the issues that are being argued right now, page 26 deals with People versus Edwards, and I pointed out pages 818 through 819 of that particular case, which we feel would be applicable.
And this has to do with state of mind evidence?
Yes, Your Honor. In addition, I believe the court indicated before lunch that we hadn't filed any motion in limine, and the issues which were presented in the motion in limine as to the defense opening statement are similar to, if not identical to, the same issues that would be addressed throughout our objections in these proceedings.
All right, I take it the defense has not had an opportunity yet to review People versus Edwards or this brief, or?
Well, I have, and even though I just got it, the discussion is about half a page in length. And if I could just briefly be heard as to why that case simply doesn't apply to this situation.
All right, well, let me look at it myself since I have not seen it.
And
I did review the prosecution's motion relating to the defense opening statements, again, during the lunch hour, but obviously now the prosecution has modified it in some fashion.
Your Honor, the modifications are basically what I've indicated. It's my understanding that the defense wants to call Dr. Briere now, and my guess is his testimony might take the remainder of the afternoon, so that these issues might be addressed later, or at least after the 3 o'clock break.
These issues do not relate to his testimony?
Well, No, because I believe Dr. Briere did not interview anybody associated with this case, and so our concern about hearsay and things of that nature would not be raised by his testimony, as I understand the offer that was made by Ms. Lansing to me as to what he's going to testify to.
All right, well, let me back up then. Does the defense want to proceed out of order and call Dr. Grier now and put him on before the jury? Is that what you'd like to do? And then,
I assumed we were going to do the 402 first. That's what the court indicated.
That's what I
We
thought,
got Lunch,
yeah.
and so we're ready to do
Okay.
the 402, and then after that, we can see how long it takes and where we go from there.
all right, that was my understanding how we would proceed, but let me get a little more information here, since this is perhaps something that you folks have been discussing to some extent, but I have no knowledge of it as far as the specifics of what's going to happen here. The people said they have some objections to Dr. Grier's testimony. Is that right? Or you do not? If you do not, then I suppose he could testify before the jury and lay whatever foundation is necessary for the continuation of the testimony of Ms. Cano.
Correct.
Is that correct?
Yes.
So that there would not be a need to duplicate Dr. Grier's testimony or have it occur more than once.
Correct.
Okay.
No,
So-
my only objection, and I in thinking about it, my only objection was that he doesn't have any personal knowledge of this particular case, and it's my understanding his testimony is being offered generally so that the jury can view the other testimony of the civilian witnesses, having then heard Dr. Brier's testimony.
Right.
Is that correct? Is that why you are calling him?
That is correct.
Right, that's what Ms. Lansing indicated she wanted to do at one point during Mrs. Cano's testimony. I want to take a break for this, I believe.
Yes.
Correct.
Okay.
And our only objection would be that he has no personal knowledge, but I'm sure the court can deal with that objection in short order.
Well, your feeling is you don't think that objection is well taken then?
Well, I'm trying to preserve the record, Your Honor, that's all.
What sort of record are you trying to preserve?
That we, in fact, objected to his testimony.
Knowing that your objection is not well taken.
Yes, that's probably right. I don't think, Your Honor, that the court is going to preclude Dr. Briere from testifying.
Okay. All right, then let's take a break then, unless there's some need for litigation of any other matters. So I guess we could do something here to allow that we can let the jurors gather. I think they were told at 2:00, and then we'd have Dr. Grier's testimony, then pick up with Mrs. Cano. But are there any lingering matters that relate to her testimony that you want to deal with now, or want to defer until after his testimony?
Well, let's do the issue of the Edwards case then, as to Ms. Cano about the state of mind exception to the hearsay.
All right. As I said, I haven't looked at it yet, so I'll be more than happy to. And I'll read it right now. I'll read your brief and look at the case. You're referring to Evidence Code Section 1252 regarding the reliability or unreliability of the circumstances of the statement.
Yes, Your Honor.
Judge, for the court's guidance, the Edwards case is very lengthy, and the discussion that the prosecution is pointing to is on page 818 through 821.
Which I just sent.
All right, I'll take a short recess to review that, and then we'll pick up. And if we have time to deal with it prior to commencing testimony with the jurors, we will. If all the jurors are here, my preference would be to have testimony before the jury if you're able to do that. I understand that you would be able to do that. Is that right?
Yes, Your Honor. My testimony, or Dr. Brier's testimony before the jury was going to be slightly broader than, it would include everything we'd put on in the 402, but it was going to go into other areas that are not. The 402 is essentially a Kelly Fry type of hearing, as I understand it, which should be precluded by 1107. But I did want to indicate that in front of the jury, there were several other areas that I would explore with Dr. Briere that I wouldn't do in just a pure 402.
Yeah.
But it would be primarily duplicative to do both hearings.
All right. Well, the people have conceded that Section 1107 of the Evidence Code applies to this case, so they're not raising a Kelly Fry type objection. Is that right?
Well, except for there is no battered child psychological syndrome. All right, so if he's going to testify about a syndrome, that's different from giving generalized psychological testimony. It's my understanding that as of this date, there is no recognized syndrome comparable to the battered child syndrome is a medical diagnosis of medical injuries. That's not applicable here. And so it's my understanding that the state of the art is now that there isn't a recognized in the DSM-3R a syndrome equivalent to the battered wife syndrome. So if he's going to be establishing a new syndrome here, then I think that's a little bit different.
He's not going to be testifying to battered child syndrome. He's going to be talking about the effects of trauma.
And moreover, just for counsel's edification, there is such a thing as the equivalent to the battered wife syndrome, and it's called different things in different states. In California, there's been a tradition of referring to the battered child syndrome to a set of physical signs that an injury or trauma on a child was inflicted on purpose rather than accident. But in other states, that same term is used as the equivalent of battered wife syndrome, and it's exactly tracks battered wife syndrome. But when the people indicated that they conceded that 1107 applied to this case, then we did not file the pleadings that we were prepared to file to show that there is indeed an entirely equivalent syndrome. And I think it's a little late for them to make claim that their agreement that 1107 applies has some limit or notification heretofore unnoticed to us.
People wish to respond to that?
Yes, Your Honor. First of all, throughout these proceedings, we have made motions to admit evidence. On March the 15th of this year, we filed an extensive motion in order to get the evidence in front of the jury. Now, Aranda is not an objection raised by the defense. Aranda says the prosecution has to make sure that the evidence is properly presented. And we filed that motion, and we have litigation framed by that motion, okay? The defense has never filed the trial brief they've been talking about filing for several months. They have never filed points and authorities to admit their evidence. We have raised issues in the motion in limine filed on July the 13th, which have not been addressed in substance, and which we did in fact raise. Now, as far as the fact of this syndrome, the syndrome is, if there is such a syndrome, it is not yet recognized in literature or statutorily. And what we've conceded is that defense experts may testify about the effects of child abuse on victims. And that is exactly what we said we would allow to happen. But in terms of how it's going to be formulated, the burden is not on us to formulate that and present it to the court. It's on the defense. And if they choose not to file papers, that's their choice.
Well, hold on one second. In regards to whether or not issues have been resolved, the motion that the prosecution refers to, the in limine motion, was filed and directed solely at the opening statements. And it was to that issue that the matters were litigated, not to what ultimately would be introduced by the defense during its case in chief. So that the matter has never been brought to the court for resolution. That's why I alluded to the absence of any documents filed by the prosecution prior to the commencement of the defense case here as a concern to the court, in that it does not alert the court to the position of the prosecution in regards to the specific evidence, other than what was referred to in that in limine motion, which now has been amended. But in that motion on page 12, the prosecution stated at line 18, quote, evidence code section 1107 deals with the admissibility of expert, and expert is underlined, testimony as it relates to the battered wife syndrome, and the people will not object to the introduction of expert, underlined, testimony which is analogous to the issues raised in evidence code section 1107.
That's correct.
Well, that seems to me that the people conceded at the time that motion was filed that whatever evidence was subject to being introduced relating to battered wife syndrome could be introduced in relationship to the circumstances of this case, including the expert testimony in regards to that. Is that right?
Yes, Your Honor, it is correct.
And would that not include testimony regarding the effects of such circumstance on a child in that situation?
Absolutely.
So,
but whether or not there's a recognized syndrome is another issue.
Well, does it matter if there is or is not, if the witness testifies about the his opinion about the effects on the individual, whether there's a title or a diagnosis in a book?
Well, it seems to matter to the psychological experts because it seems that the DSM is an attempt to categorize symptomology into syndromes for handier use. And it's my understanding, at least at the time that I wrote this motion, from talking to people in the field, that there is not yet a recognized syndrome analogous to the battered wife syndrome or the rape trauma syndrome. But rather, I believe Ms. Abramson pointed out in her opening statement that it's really a post-traumatic stress disorder. And we would not object to that kind of testimony, but to then today in this courtroom coin a new syndrome, that is not, it's not in the literature, and that is not what was contemplated by our motion or our concession.
Your objection is just to the use of a phrase that has quotations around it and a title to it as a diagnosis, but you have no objection to a witness testifying to the underlying analysis and impact or the effects it has on an individual.
That's correct.
All right. Did the defense wish to respond at all to this?
Your Honor, this is premature. It's certainly Dr. Greer isn't going to testify that anybody is or isn't at this moment suffering from such a syndrome, but as we get down the line, if we feel it is necessary, I think we could probably have a 10-minute Kelly Fry in which we can bring in all the experts who have been testifying and all the other parasite cases around the country who have testified that there is an absolute equivalent syndrome, if that's how we choose to go.
Also, there's one additional
We can
point.
file all the briefs. We can file with the court, in fact, transcripts of the Kelly Fry hearings in those cases.
Well, again, I don't know if we're debating something that really has no significance as to whether someone is putting a title on something or testifying to the substance of the impact on an individual. Really, at this point, I don't think it matters if the people are conceding the underlying evidence is admissible. So I'll take a short break here. We'll determine whether our jurors have all returned, and I'll review the Edwards case and the supplemental brief filed by the prosecution at this point. And as I said, if we have all our jurors here, my inclination is to start up with the jury's stop the testimony of Mrs. Cano at the moment and resume after Dr. Greer has testified. So let me take a recess until we determine if our jurors are all here.